Yes. Huh? Infructuous. Yes. 16, 17, 18. Actually, all are infructuous. Actually, 10, 10, 20, 21. So
But
that
I am
is,
for the response 7.
huh?
I am for the response 7.
Okay, Mr. A.K. Hussain appearing for the petitioners in WPC 2444-2021 and 6209-2021 submits that the writ petitions have become infructuous. You are appearing in which case?
Lordship, item number 18.
18.
18.
Mr.
DJ Medi.
DJ Medi appears for respondent number 7 in WPC 6209/2021. In view of the above, the writ petitions are dismissed. In view of the submissions, in view of the submission made by the petitioner's counsel, which is not denied by the respondent's counsel, the writ petitions are dismissed as infructuous. What about 16? Who is there?
Please also, I have seen this.
I know it is also it's of settlement of 10-10-21.
Similar matter, my lord.
I know it just few days, 2 weeks back, it has become infructuous.
Period is offered, my lord.
Period is over, right? No one appears for the petition on call. The matter pertains to settlement of a fishery for 3 years with effect from 10-10-2021. As the period of settlement is over as on date, comma, the writ petition has become infructuous. The writ petition is accordingly dismissed as infructuous. Forty-four and 45. Yes. Petitioner. The accordingly, the prayer for adjournment is allowed.
Well, I'm for
Just right before that, right, Mr. S.K. Medi submits that he has got no objection to the prayer for adjournment.
that right may not objection.
If they have got
Yes.
operation, what?
Yes,
You are objecting, all right?
I'm not objecting.
Then what will I write?
But
What do you want me to write? You're objecting or not objecting?
No, madam, I'm not objecting.
Then that's what I'm saying. You're not objecting.
But in department, sometimes they are difficult.
Oh,
Yes.
okay. Okay, just say Mr. S.K. Medi, CGC appears for the railways.
Yes.
The in view of the fact that Mr. R.B. Phukan has undergone an operation, the matter is adjourned.
My lord, only my lord, there is some stay is there, my lord, termination. So
For how long?
we propose, my lord, 14th of November, my lord, or 14th of November, propose, my lord, 14th of November, my lord. My lord, no, it was not there, my lord, earlier, my lord.
Not there.
Not there, my lord.
This is the matter of 14th.
14th of November.
What is this IA? But what is this IA for?
My lord, the IA was for some for time, my lord. It is already there. After that, it was not continued, my lord.
Time for what?
My lord, is so far, my lord, there is some payment. We recovered some amount, my lord, for not to recover further amount. My lord.
Okay.
Yes.
Okay, right. Next. Item 40.
Item 40. So we will file affidavit in open. We need other 4 weeks time.
You're for the respondent.
Yes, present.
You're for OP number.
Be the private party.
Who are they? You have no idea. Huh? You're the husband of that lady who is in illegal occupation of the official quarter. What time? You are only asking for to help your wife. You are in illegal occupation. What affidavit will you file? What will you file? Your wife has already filed.
My leading counsel is based on due to fracture of this file.
Who is for the other side? Yes.
But I thought that counsel for the respondent, private respondent.
Why is it, why are you asking for time to file affidavit? Just to support your wife, who is in illegal occupation of a quarter.
After two, yeah.
Maybe, but right now we're interested in you only. Okay, right. A German prayer has been made on behalf of the
That's good. So,
respondent number 14. Huh? 2 to 14. On the ground that,
we find affidavit and otherwise my leading counsel is also bedridden
on the ground that the leading counsel is bedridden.
due to fracture of.
So the further, they want to file an affidavit within,
4 weeks.
why 4 weeks? Within 2 weeks. This is the matter. 2 weeks time is granted to file affidavit. This is the, say 4 weeks, huh? He's asked for 4 weeks. The time of only 2 weeks is granted to the respondents to file their affidavit. This is the matter after 2 weeks.
May I please, your lordship? With the consent of the other side, I beg to mention item number 4 of today's list for adjournment on behalf of Mr. M.R. Adhikari, as he could not come to the court due to his ill health.
Madam, this 2016 matter, what do you want? Adjournment?
Adjournment.
Why?
Mr. M.R. Adhikari could
Huh?
not come.
Who couldn't come?
Sir, Mr. M.R. Adhikari.
Adhikari is not here. His name is not here. For the
CGC.
Okay, right. Adjournment prayer has been made on behalf of Mr. M.R. Adhikari, CGC, who is reportedly unwell. Accordingly, release this matter after,
Next week, your lordship.
release this matter in the next. Release this matter after a week. Item 39. What do you want? Huh? Infrastructure. Yes. 2023. So, who is for the respondent number 3? Okay, right. The work has been completed by the respondent number 3, probably. Huh? Or petition has expired. Okay. Mr. Huh? DG Gogoi learned counsel for the petitioner submits that the writ petition has become infected as the petition has expired. Stop. In the submission made by the counsel for the petitioner, the writ petition dismissed as infected.
I beg to mention item number 49, my lord, for adjournment.
49. What do you want?
My lord, my senior is in under medical treatment, my lord. So, my lord.
Your
I-
father? Your father?
Respond number
4 and 5, 5 and 6.
5 and 6, Mr. T.R. Gogoi.
Ah,
my
you have
senior.
got to file your affidavit. That's why you are to file your affidavit. Where's the affidavit?
My lord, you do not file the affidavit till now.
That I know. That is what the court directed you to do earlier.
But sir, my lord, he is under medical treatment due to
Who
severe
is the counsel under medical treatment?
T.R. Gogoi.
T.R. Gogoi.
Yes.
Right. Adjournment prayer has been made on behalf of Mr. T.R. Gogoi, learned counsel for the response number 5 and 6. To start. It is noticed that on the last, as per the last court order, the respondent number 5 and 6 go to file their affidavit in opposition. However, the same has not been filed till date. The respondent number 5 and 6 can file their affidavit in opposition within
2 weeks.
2 weeks. This is the matter after 2 weeks.
May please your lordship. Lordship, a date may kindly be fixed.
Give it, what date? Give a date. After the.
Much of less.
This connection notice has been issued and the last date for disconnection is tomorrow, your worship. And this has been heard and the matter.
I doubt it will become effective.
Disconnection is tomorrow.
Luckily, the summer is, now winter is setting in, not so hot. Okay.
May I lordship, with the consent of the other party, I beg
Huh?
to mention, with the consent of the other party, I beg to mention item number 9.
9.
Yes,
Yes.
the standing counsel, Mr. N.J. Gogoi is out of station due to some emergency.
I'm there.
Kindly, sir,
Already, informed.
Huh?
I'm for the
I
petitioner,
inform-
informed.
Levy of cess on timber.
This cannot be.
I don't know. Anyway, right. Adjournment prayer has been made on behalf of Mr.
NJ Gogoi.
N.J. Gogoi. Learned counsel for the
Respondent number 2 and 3.
respondent number 2 and 3. Accordingly, leave this matter after the week. Give a date. This is the matter of 8 November. Interim order which shall continue till the next date. Keep your faith. You pray for listing. Once it give a date.
November.
5th November. Okay.
Lordship, I'm mentioning for item number 13 and 14, my lord, that both matter become infractions, Lordship. The petitioners got the relief, my lord.
Okay, where's the petitioner?
Lordship, I'm for the petitioner.
Oh, you're for the
Yes,
petitioner.
Lordship.
Mr. R.K. Talukdar, learned counsel for the petitioners in WPC 6139 of 2021 and WPC 6138 of 2021. Submits that the writ petitions have become infructuous, inasmuch as the vehicle hire charges of the petitioners
Already released.
have been released and paid to them.
Lordship.
In view of the submission made by Mr. R.K. Talukdar, the writ petitions are dismissed as infructuous. Huh?
I'm waiting for listening of a matter. This matter was listed last year. In the month of September. This is regarding.
When do you want?
So 4th of November, your worship, after Diwali.
Item number 15 of the day. Well, this matter has become important. It was regarding a supply of.
Supply of 7/9/21.
Yes. I have already.
Mr.
Yes, Bishop.
S. Vishwakarma, learned counsel for the petitioners, submits that the writ petitions have become the writ petition has become infructuous. Mr. K. Gogoi appears for the respondents. The writ petitions accordingly dismissed as infructuous.
Please, your lordship, I beg to mention a writ petition for withdrawal.
Which one? Okay. When?
Any date, lordship.
Tomorrow?
List of motion item 1.
Yes,
Lordship, as per my instruction,
63,959.
2,63,959 is still pending, Your Lordship, but the problem is that, Your Lordship, Ministry of Jal Shakti is not a party here.
Madam, when you see the initial claim
Yes,
was for 1,59,00,000.
yes, yes,
You have already paid 1,56,00,000.
yes.
Now what? Now you have got to pay now only 2 lakh something. Suddenly you come up now Jal Shakti.
No.
You have already paid 99%.
Lordship, that may be released from the central, Your Lordship. That is why we could pay it, Your Lordship, because Lordship, major party is from central government. That is the fact, Your Lordship.
But is
Now-
Jal Shakti a party?
Not party, Your Lordship. Present position also, I do not have what is whether they had released the amount or not, by the central government, Your Lordship. Lordship,
What to do? Now this stand has been taken by them in all the other cases also. You see, the thing is now, what they are saying is actually not only Jal Shakti and the Brahmaputra board also have to be made a party, both of them. So I think better for you, instead of making all these amendments, you just withdraw this, you file one, putting Jal Shakti and this other one a party. Okay. Then it will be, then I think everything will be sorted out. Then we can pass a effective order.
Yes.
Otherwise, the order that can be passed will be passed today. Might not be implementable. So it will not suffice, it will not be sufficient to pass. It will not be, proper to pass a implementable order. So you should do that, I think. What do you think?
I think then I may be allowed to.
Withdraw with the yes. Okay, right. Heard Mr. P.K. Mazumdar, learned counsel for the petitioner, who submits that in view of the stand taken by the state respondent, that the payment of the balance amount of rupees 2,63,959 could not be done due to non-release of funds by the Ministry of Jal Shakti, he would like to withdraw the present writ petition and file the same afresh by adding the Ministry of Jal Shakti and the Brahmaputra Board as parties in the new writ petition to be filed, in the fresh writ petition to be filed. Ms.
Hardek.
R. Deka, Learned Counsel for the Water Resource Department, submits that though 99% of the petitioner's bill amount of rupees 1,59,44,220 has been paid, the remaining amount of rupees 2,63,959 has not been paid due to the fact that the Ministry of Jal Shakti has not released the entire 90% share of the funds for payment of the contractor's bills in respect of the schemes undertaken by the center and the state government. Full stop. In view of the prayer of the petitioner's counsel, in view of the prayer made by the petitioner's counsel, that he would like to file the petition afresh, and keeping in view the submission made by Ms. R. Deka, this court is of the view that the prayer of the petitioner's counsel should be allowed. Accordingly, the writ petition is dismissed as withdrawn, with liberty of faith. That it becomes easier next time for you all.
I didn't do.
Petitioner is the lessee in the Cooper of the tourism developer. He was appointed as the lessee of the government of Assam. They have introduced a policy to develop certain tourist spots with participation of private party. Accordingly, Assam Tourism Development Corporation, they were appointed as the nodal agency for doing all the lessons.
So what is their problem?
Now, I was.
So the agreement is not being followed.
Yes, madam. I was appointed.
Why don't you file a specific performance of contract?
No, I was handed over the 12 structures. 2 structures have not been handed over to me.
Have you filed any representation?
Yes, madam.
Where is that?
The last representation, that is at Annexer 8, madam, page 69. Prior to that, I even 2 more representations against that they passed certain orders, madam.
What is the date of this?
Last representation was date. They received it in around 21st of August.
21st of August of this year.
Yes, madam.
And when was the first representation made?
First representation was in 23, madam. Agreement was signed on 2023, 29/5/2023. As per the agreement, I was to hand over 14 structures in the Eco Park. Out of that 12 structures, they were handed over to me.
What do you mean by structures? You have to run the eco park, correct?
Yes, Lord.
Then
There are certain this thing.
so there are 14 structures under the eco park.
Yes, Lord.
And out of the 14 structures,
out of it, 12 have been handed over to me, Lord.
okay.
2 main 2 ports.
Yes,
Your Honor, my senior is in a different matter.
we'll wait for his senior. Huh? Have you given a copy of this? Huh? ONGC has no standing on. Okay, tell me. No, this, you see, this earlier tender, the issued by them is for what?
The fabrication really of the oil rigs, etc. pipeline, this is the heavy duty work. So that this honorable court had passed in very modern in that paper where it says Annexure 4. This honorable court has passed this order. The relevant court becomes the interpretation of the interpretation external monitors is by us. And the last is the law the court is directed. It is further appears from the communication data gist, which is it shows the gist of the research. The independent external monitors are examining the demand of the respective file. As we have rejected the data by doing the party, interpreted the extended thought according to its advice. According to its advice and the authorities to review the limitations, therefore the faculty appears that the monitoring the person have actually not been principle. As such, pending execution of the research provided that the technical field of the respondent number 5 will not be reconsidered by the temporary authority without legal. That was a debate. Now, if doing this, it did not bring, it did not find the evidence. After taking a number of times, they will serve it. Thereafter, instead of responding to this, what they have done, they issued the same data for a shorter period. I'm just repeating the words here. Basically,
So they are making the earlier tender notice redundant.
they did that.
Anyway, let's see. Right, third Miss M. Hazarika. Then it's senior counsel for the petitioner, assisted by S. Newar. Newar. The petitioner's case is that the ONGC had floated tender dated 2/2/2024. For rate contract for repair / fabrication works, paintings of rigs and equipment and bunkhouse repairing for a period of 3 years for drilling services, Assam asset. First up, the bid was a 2-bid system, that is the technical commercial bid and the price bid. Para 4. It is there. Next para. The techno-commercial bid of the respondent number 5, is it? 5 was rejected. However, in view of the opinion given by the independent external monitors, IEM, via communication dated 4/6/24 and email dated 25/6/2024. The respondent authorities were in the process of reconsidering the techno-commercial bid of the respondent number 5. Who according to the petitioner was not qualified. Next, the petitioner accordingly filed WPC 3345 of 2024, and this court passed an interim order dated 27/6/24. Directing the authorities not to reconsider the techno-commercial bid of the respondent number 5, without the leave of the court. Next paragraph. The grievance of the petitioner is that the ONGC has floated a new tender notice dated 8/10/2024, 8/10/24, regarding the same subject matter in issue, with minor alterations, thereby attempting to render the earlier tender notice dated 2/2/2024 redundant. The petitioner's counsel submits that the ONGC has not participated in WPC 3345/2024 till date. Puस्तक. Issue notice returnable in 3 weeks. Petitioner to take steps for service of notice upon the respondent numbers. On all the respondents by registered post with AD within 2 days. In addition to the above, the petitioner shall serve notice by way of dusty service upon the respondents and file affidavit of service within 3 weeks. List the matter on give a date. 12 November. 3 weeks. 12 November. Huh? It will not be 3 weeks. Is it 3 weeks? Okay. In the interim, the tender process pursuant to the tender bearing number R16 DB2 4007 dated 8/10/2024 shall remain state till the next returnable.
46.
Where is the other side? The other side is also not here.
Madam, is here, madam. Actually, I have to inform him that madam is on the.
Next.
47. Same matter as in item.
Same matter.
Same.
Uh,
The WPC 3345/24. I am the respondent number 5, the earlier petitioner in item 3.
is the
The petitioner in that, the petitioner in today's item number 3 is also the petitioner in 3345.
okay, yes.
I am the respondent number 5 in the item.
Acha, you're the respondent of her. Hey, why didn't you appear?
He is the end I came to my. Should may saying what
How will it be the same order? What is your prayer here?
my place is also the same, that because that matter is pending, it fixed before your lordship otherwise on 28/10. And in the meantime, because what has happened in this case,
But that writ petition is against you.
that petition is against me, my lord, and that petition, my lord, they have challenged the.
Now then, you see, I had fixed that after 3 weeks. It should have been fixed together.
Yes,
It should have been fixed. You should have risen.
my lord, the issue in that petition and this are not the same,
Oh, not the same.
not the same. Here there is items of no role. Both the petitioner's grievances and my grievance is that the second tender has been issued, while the first is not neither.
Okay. So you all are both challenging the state.
Yes.
Okay, right. Heard, Mister?
Yes.
Learned counsel for the petition. Who submits that? The subsequent NIT dated 8/10/2024, which is having the same subject matter in issue as the earlier NIT dated 2/2/2024. Should be set aside. He submits that the petitioners techno-commercial bid pursuant to the NIT dated 2/2/2024 had been disqualified. Stop. However, what is that? However, the independent external monitors, bracket IEMs, right, had advised the ONGC to review the technical bid of the petitioner herein, who is the respondent number 5 in WPC number 3345. That is which serial number? 3345.
No, the repetition number.
No, the one that I just heard is M. Hazarika. That is 5338. 5338 of 2020. First up. The petitioner's counsel submits that the challenge made to the advice given to the ONGC by the IEMs is under consideration not only in WPC 5338/2024, but also in WPC number 3345/2024, which is to be listed on 28/10/2020. Mustafa, accordingly, list this matter on 28/10/2020.
You may
That's all.
indicate that.
Huh?
You may indicate that. Just that. You know, it's
Already in the other order I've said.
It's DTAC, thing.
Okay, in the meantime, status quo with regard to the NIT they took 8/10/24 shall be maintained.
Timing,
48.
Huh? 48?
No, no, 8.
Date is same. The date is 28. I put this on 28. Because let it come together with 28. And then probably we'll have to again fix it with the other case.
It has to come with the item number 3.
Correct. Now item number 3 is on 16. 12/11. Okay, list the matter on 12/11. 12/11. So that means that 28 on 28, nothing will happen. That means on 28.
If your lordship decides one way or the other, it will have an impact.
Okay, on that. Yes. So this will become either redundant or not.
time being item 2.
Item number 2. Yes.
Yes, my lord. My lord, may I come to the page 67, my lord.
67.
67. There was a minutes of meeting, my lord, regarding our non-delivery of 2 structure, which he has mentioned, my lord. Block 1 number 141, Mackenzie, 41, my lord. One not
Four what?
Four block.
For
Block mark, point 1, my lord. Mechanism for giving access to ATDC cottage from gate 1 to be developed, my lord. So I have to take instruction, my lord, what development has happened, my lord. There was as per this minutes of meeting, that was to be developed, my lord.
has it been developed?
Yes, Lord. That was already development, and after that means the bidding was started. That was started in 2022.
No, my lord, this minutes of meeting is of 2024, my lord. Page 65, my
Now,
lord.
what was before? Prior to the bidding process started, the eco park was managed by a local committee, development committee. That was headed by the SPO Civil, North Salvador. He was the chairman. Then other officers were there. They used to manage the entire district. Then the government started this process that all the storage spots will be developed and managed by participants of the private party. And after that, they
You see, one thing is that he taking instructions, probably the instructions will never come this year. It's a likelihood. Or can we ask them to dispose of their representation by a speaking order?
Already one speaking order is there.
Or-
I have an exact speaking order.
Where is that?
That is. Annexure 5, my lord.
Page?
On the
Next up, 5 is.
annexure 6, my lord. Page 62 and start at 62, my lord.
Yes.
That was a speaking order passed by the EDC, my lord. And in that speaking order, it's a long order. They already stated that these two structure has to be handed over to the lessee, my lord.
Where? Where have they said?
That is the last paragraph of page 62. Continues to page 63. The first paragraph, whether it remains the fact that the main revenue on it is quite clear. Are the already work and so potentially.
You see, one thing, Mr. Chetia,
Yes, ma'am.
whether the entry or exit has been made or not. You hand it over to him, it is his lookout. What is your problem?
Yes, the government has taken the decision.
You see, what is your problem? He has participated in a tender
Yes,
and he has been allotted the entire voting structure.
Yes, ma'am. By the-
Whether it is complete or not, that is not your lookout now.
Yeah.
You give everything to him.
That is, we have no more difficulty.
Huh?
But because, my lord, in that aspect, we have no difficulty. But
Then-
why it was not given as LS by the petitioner, my lord, that I have to take instruction on, because as per this
You
minus.
see, there is a speaking order of 7th February 2020.
24, my lord.
7th February.
Yes, my lord, 7th February.
Yeah.
Thereafter, my lord, this minutes of meeting is of 19 July 2024, my lord, page 65, my lord.
After that, I gave a letter to hand over those two structures. Then the DC called for a meeting, my lord. It was held in the circuit hall.
In that meeting, my lord, this decision was taken, my lord.
Again, in that meeting
Huh?
also,
In that meeting, my lord, after that February, my lord.
You
order,
see,
my lord,
you have asked for a tender to be floated. Yes,
tender by him, my lord.
yes, yeah, and has participated. Now everything should be given to him. What is so difficult?
I paid the entire money, my lord.
Correct.
My lord, that's correct, my lord, but as per this, my lord, it was to be developed, my lord. That is why it was not.
But you see, forget about whether it is developed or not.
Hmm.
Even if it's not developed, you give it to him.
That's what I.
Let him look as per the agreement. What is so difficult? Why are you delaying? When he wants it undeveloped, let him look after it undeveloped. What is there? You are not developing it. You obtain instructions by
Yes.
day after tomorrow.
Yes.
Right. Heard, Mr.
Our secret.
R. Shekhar, Learned Counsel for the petitioner, who submits that pursuant to an agreement dated 29/5/2023, signed between the Assam Tourism Development Corporation Limited, (ATCL), with the petitioner for management, development and operation of the Koya Kujia Eco Park for a period of 5 years, the ATDCL was to hand over 14 infrastructures to the petition. However, only 12 out of the 14 infrastructures have been handed over to the petitioner. Mr. M. Chetia shall obtain instructions as to why the 14 infrastructures have not been handed over to the petitioner.
Who, my lord?
Why 2 of the 14
If I
infrastructures?
may interfere, this is not his case. He is not agreed by the fact that the ATDC has not handed over.
I am appealing for ATDC. ATDC has handed over all the 14 components to him.
Occupied by the earlier development committee, headed by the SDO.
That's a different, that is the case here. So Koyak.
So those
huge
two
ecological park.
infrastructures, the people are still occupying it.
No, it's not like that. If I may explain your lordship, Koyak.
Then what, Mr. Chetty, what are you saying also?
No,
my lord, as per this, my lord, minus my lord, the
You have no idea.
SDO needs to explain this actually. The instruction is to be obtained from the SDO.
yes,
Because he is heading the committee who is looking after
No,
the
what,
overall
so,
Koyak
so,
project.
so two have not been handed over to him.
yes,
Yes. Two things is, one is the access, the gate, and the other one is the parking, if I have understood correctly. Yes. The parking and the gate, your lordship. Now, this Koyakuji Eco Park is a huge area. Within that park, ecological park, we have constructed ATDC, Assam Government Tourism Development Company. We have constructed 14 components.
So you just have to hand over the gate
Those has already been handed over.
and the
But
parking
regarding
area.
the access and the parking,
Why it not been handed over?
there are multiple parkings and multiple parking spots here.
So you're making
So
for money
they have,
purposes.
as per the minutes of the meeting that I have gone through today, a mechanism for giving access to the ATDC cottages from the gate number 1 will be developed. So a mechanism has to be developed. That is what this minutes of the meeting.
Look, whether it's developed or not, he wants it.
No, it's not about the gate being developed. It's a mechanism to give access to the gate. They are talking about
What do you mean by that?
that SDO will understand you.
You see, this is all this is all jargon, usage jargon, which probably which probably the people the officials are making money and denying him his rightful right to make some profit out of it. What do you mean?
From our side, proposal.
What is the let the SDO, you bring the SDO.
Yes,
I will take instruction,
Huh?
that is why I have to take instruction, my lord. Why?
Not instructed, you bring the SDO. Let him explain. There's a speaking order. This is of 23, Mr. Council. There's an agreement.
From the corporation side, we don't have any problem. We have already handed over. The handing over.
You are appearing for whom?
I'm what my lord,
DC.
DC, my lord.
SDO and DC.
Yes.
You bring him, tell him to come.
SDO is the my lord, chairman of that committee, my lord.
Then you bring him. You obtain instructions and bring him. Why is not handing over? What have I said? Full stop. The entry to the eco park. Entry and the parking in the eco park have not been handed over to the petitioner. On the alleged ground that a mechanism for giving access to the ATDC cottages from the gate number 1 is to be developed. Mr. M. Chettiar shall obtain instructions as to the meaning of the word mechanism reflected in para 4 of page 67 of the writ petition. And as to why the agreement has not been followed by the respondent number 8.
My lord, he just
The respondent number 8 should by the next day give appropriate instructions to Mr. M. Chettiar. List the matter on Friday. After tomorrow.
48. The manner in which the draw plot was conducted by. In a usual practice manner, they used to conduct draw plot by using Foxy balls method.
By using
The house
balls.
ball.
Now they use paper.
If I get to my Delhi in an online mode manner, and at the time of ongoing my this draw plot, my objection was raised manner by the petitioner's manner through email. But they continue with the draw plot manner.
But what so what happened? Is there some cheating took place or what?
That is not properly reshuffle number 1 mallet. Number 2 mallet will say I made a technical statement in the petition mallet that prior to issuance of this tender and prior to issuance of this tender mallet in all subsequent tender mallet, they are using the method of housing ball. Only for this particular tender mallet, they are using this.
So can't they change? There's a particular Does a particular draw where the draw of lots is conducted, does it have to remain for all times to come?
No, what has not been prescribed, but now suddenly changing the prevailing practice by the 1GC, my lord.
Unless you show that some prejudice has been caused to you, there is a draw of lots. What is wrong?
My lordship,
You show me some citations that draw of lots cannot be held in by way in the manner it has been done.
it's a policy decision, I will not say this, but they have taken up, but my lord, but there should be some reason, my lord. Suddenly they are that to in an online mode in Delhi, my lord. If my statement is there, categorical statement is there, my lord, they have been in a categorical manner, I have stated my kids and my lord. They have been following the mode of housing balls, my lord. Now only for this particular.
Housey
my lord,
balls.
only for
What
this
balls? What balls?
But the playing the housing game, my lord.
Housey game. Tombola. Tombola.
Tombola, exactly, tombola. Now, my lord, only for.
So those balls that are used for the numbers, that has not been used. Instead, they have used paper
Paper in
and put it in that same round thing. Yeah.
My lord.
What is wrong?
But my lord, that is my lord, because it was held in Delhi, my lord, and we
So-
were here on online mode, my lord. And in the course of this, my lord,
Wasn't it done video or something you could not see?
we have raised objection immediately, my lord, in the ongoing draw plot, people said page 167, and then my lord, page 169.
Yeah.
Page 167, my lord, in the course of this draw plot, we have raised objection in the email, my lord. And then lordship 169, my lord. I am watching your Zoom regarding draw plot. I say Assam, but not satisfied the system. Because during the course of this draw, my lord, we have raised objection. It is not that subsequently, after not getting this thing, we have raised objection.
You see, with the ball system, in fact, you can see the numbers.
Yes, ma'am.
With
No.
paper, you cannot see the numbers. When you do you have played Housey number of times. Huh? Two fat ladies, 88. Huh? All those. Huh? So you can see the numbers also when you're going to take out. But papers, if it's there, you can't see the papers. You can't see the numbers in paper.
Only for why for this particular thing that they have taken this mode. Otherwise, they have followed even subsequent tenders, they have followed. Let them explain for this code, my lord.
Yes.
I fully agree. Had it been below 99, the Housey was the right option. But when we are having 147 in sub 1,
147.
yes. And in the sub 2, 252. So in Housey, you cannot have 100 more than 99.
So altogether, how much?
It will be around 400 something.
No, 399.
Yes. So, and what we have done, Lordship, we have given them 7 days notice. Everybody was invited.
Acha, was invited.
Everybody 7 days. On 27th September, we send the email.
Okay, just a minute.
On 27th
September 24.
we have, I have the email also with
Email sent to all.
Indicating the venue, time and place. Venue, time. This is the email. Date, venue and time of the draw of lots. And lot is permissible under the contract, Lordship.
And that you're going to do it by way of paper was
Now,
mentioned.
we have what we have done. We have collected identical envelopes from the Amazon, Lordship. We have the slips and the unique identification number and the word inside that envelope. Envelopes are all identical,
All sealed.
all sealed. And we have invited them
And it was inside. The
inside
numbers
the
are there.
acrylic box.
Yeah.
And it
No,
was
So
sub
in the envelope, one envelope.
envelopes are all sealed.
Envelope will contain one number.
One 6-digit number,
6-digit number.
6-digit unique number against each bidder. And we have to find 50 in each category.
Just a minute. One envelope will contain 6-digit number.
6-digit unique identification number against each bidder, which is known to them. The work also is indicated in the slip. And in each envelope, these slips were inserted and it was sealed. We have collected one acrylic big box, which is rotating,
Okay.
identically with the Housey Tombola system.
Okay.
one officer was rotating it, one officer is collecting it, and it was submitted to the third officer. And he is noting 3 representatives from their side. All the contractors sent 3 representatives. They were present.
He said
Everything.
that they were not present.
No, he did not go. He
Petition-
was invited. He
Hey,
got
your
the invitation.
representative went.
He should not have gone.
Huh?
It is not association, individual citizens were there, persons were there.
So,
They were all present.
First of all, madam, more.
And on top of that, we have given a Zoom link to everyone who wants to watch it.
no, so, and, no, and
It
during
was,
that,
yes,
during, in that acrylic ball,
Yes.
that was, envelopes were there. All 399 envelopes.
all. And after 50, we continued it because
What do
somebody
you
may.
mean 50? You took out 50 first.
No, we take one by one.
Ah.
After 50 also, we continued till the end.
Ah.
Because somebody may raise an objection that
Yeah.
my number was not there.
Ha.
So everything was done.
Okay.
So we have the wait listed also now. Suppose from that.
So
50,
who was the one selected?
there's
The first
names
one.
I can- I
No,
can names.
so the first envelope that was taken out was selected.
Yes, one by one it was collected
Ah.
by one officer, handed over to the second, he opens it.
No,
And-
who was the successful tenderer? The first envelope that was taken out? Or
We
the
have to select 50 in each category,
50 in each category.
each category,
So how many categories are there?
2 categories. So 100 we have to
100.
select out of around 400, Lordship. And we have the complete list of everyone in serial term.
Anyway,
So he could have watched it also live.
great.
The mode was not discussed, notice.
Huh?
Notice was issued, maybe was notified, my lord, but mode was not notified. And
Your representatives are there. How many representatives did you send?
each one person has 5 minutes, individual investment. There was no question.
Mr. Counsel, please understand the question.
My-
It's very simple.
my-
I did not ask how old you are, or what is your weight. I asked you how many representatives did you send?
I didn't discuss my knowledge.
431.
I'm not asking about the present petitioner. Do you understand the meaning of representatives? Then how many representatives do you send?
It's 1A, 140,
You don't-
149. The total figure is, Lordship, I am just correcting myself. 282 in one category, 149 in the second category, total 431.
282 plus 149, 147.
140, 149 and total is 451, 431,
431, yes.
430. That is the exact number.
Okay.
My lord, the grievance was there, I didn't like matter.
If required, we can file a short video. We have videographed everything. If Lordship wants to have a look at also, we can produce a video here.
It is, I think, subsequently after conclusion of the.
No, you can raise it, but it is not always acceptable. Just for the sake of objecting, one can raise objection, but there should be some genuinity. If he had got it, Lordship, he would not have come here.
No, yes, 50, very good chance of getting.
Yes, Lordship.
Yeah.
Of course, not the current, because
The first of line, middle of
Anyway,
line.
job done, thick repetition file. Anyway, right. Right, Mr.
highest
R.S. Mishra, learned counsel for the petitioner, who submits that the ONGC had floated tender number ZV9 SC 24007 for 3-year rate contract for construction of drill sites and approach roads in operational areas of Assam asset for the year 2024-2027 in a single bid system at an estimated cost of rupees 3,11,70, no, just say 311,70,10,154 for subhead 1 and for rupees 43,63,75,602 for subhead 2. Full stop. Next para. The petitioners participated in which one?
it was the
participated in both the subheads 1 and 2. First of, as the bidders had all submitted bids quoting the same rates, comma, the respondent authorities decided to select the successful tenderers by way of draw of lots. First of, however, the draw of lots was not conducted as per the prevailing practice, comma, that is, by using the numbered balls that are used while playing tambola and which are rotated in the circular steel frame used while playing tambola. And you don't say housey. Housey is for persons who don't know the how. Yes, but I think people will understand tombola better. Tombola bracket housey, you say, huh? Next paragraph. The petitioners council submits that the petitioners were located in Guwahati, Sibsagar, Assam, and the draw of lots was conducted in Delhi, where the petitioners were not present. He submits that as the draw of lots was not done as per usual practice, comma, that is by using the tombola numbered balls that were rotated in a steel frame, comma, and as the same had been done by using paper, had been used by using papers which are paper slips which were numbered, comma. The same has caused prejudice to the petitioners. He submits that when there is a prevailing practice for conducting draw of lots by using the tombola bracket housey numbered balls, comma, the respondent authorities could not have deviated from the prevailing practice by using paper slips. Next para. No, next para. No, then they say he accordingly prays that the selection of the successful tenderers but by way of draw of lots conducted on 4/10/2024 should be set aside. Next, Mr. D. Saikia, the learned senior counsel appearing on behalf of the ONGC, submits that there is no denial with the fact that the prevailing system for selection of successful candidates is done by way of draw of lots using the tombola numbered balls. However, in the present case, the selection of the successful tenderers was in respect of however, in the present case, 50 successful tenderers were to be selected under subhead 1 and under and another 50 successful tenderers under subhead 2. As there were 149 applicants, tenderers, in respect of
bidders.
subhead
Subhead 1.
1 and 282
Subhead two,
tenderers in respect of subhead 2,
total 431.
thereby totaling 431 tenderers, There was no, it was not possible to use the tombola
Balls.
balls, which would have allowed for conducting draw lots if the number of candidates was 100 or less. Not even 100, actually
99.
100, because 0 will be there.
Yes.
100 or less. Next paragraph. Mr. D. Saikia further submits that in the present case, a slip containing a 6-digit unique identification number and the concerned work was allotted in respect of each tenderer, and the same was put in envelope.
431 identical envelopes.
Was put in identical envelopes. Accordingly, 431 slips were put in 431 envelopes, and the envelopes did not contain any writing or identification mark. Full stop. Prior to the draw of lots being held, the petitioners were all informed by way of an email sent 1 week earlier to the holding of the draw of lots, informing them the venue, date and time the draw of lots would be held. They were also asked to participate in the proceedings during the draw of lots, and the petitioners were represented by their representatives.
3 persons came here.
And the petitioners were represented by 3 representatives during the draw of lots held in Delhi. Further, the tenderers were also allowed to see the proceedings, that is the draw of lots, by way of a Zoom link. He submits that in terms of the draw of lots held by spinning the envelopes,
Spinning them in a acrylic box.
in an acrylic box, 50 successful candidates were selected under subhead 1, and 50 successful candidates were selected under subhead 2. Further, even after selection of 100 candidates for subhead 1 and subhead 2 together, all the envelopes were taken out one by one and opened, so that none of the tenderers could later say that their numbers were not included in any of the envelopes that had been put in the acrylic box, by which the draw of lots had been held. Accordingly submits that in view of the real state above, the petitioner's writ petition should be dismissed.
It was a total fair game, transparently done.
I have heard the learned counsels for the party. The petitioner's counsel has not denied the fact that there were more than 100 tenderers who tenders whose selection was decided by way of draw of lots in the manner submitted by the learned counsel for the ONTC. So on considering the submission made by the Land Council for the ONGC, which has not been disputed, this court is of the view that a fair and transparent method of selection has been held by the ONGC in selecting the successful candidate. Accordingly, this court does not find any ground to interfere in the selection of the successful candidates pursuant to the NIT dated and tender number ZV9 SC 24007. The writ petition is accordingly dismissed.
Highly obliged, sir.
Till 5 and 6 permit.
May I please your lordship? Lordship, yes, yesterday we have paid 1 lakh rupees to each the petitioner, lordship.
We have paid 1 lakh
Part-
rupees each. Yes.
One,
Paid.
we need some more time to.
How much is remaining?
Petitioner number 1.
For Ratan Boro, how much?
For Rotonboro, balance is 13 lakh 59,996.
1359
996.
996. And for
Mon-
Manin,
Moninboro 644,897.
that is after payment of the 1 lakh.
That is before payment of 1 lakh. Yesterday we have paid this.
So it will be minus 1 lakh.
Yes.
Okay. So 1 lakh each you have paid.
Is a paid.
You have got that. Okay. Miss
J. Gogol.
J. Gogoi, counsel for the ASTC submits that the ASTC has paid rupees 1 lakh each to the petitioners Ratan Chandra Boro and Manin Boro. Accordingly, he submits that as on today, the payable amount to the petitioner Ratan Chandra Boro, WPC 1910-2017, is rupees 12,59,996. While it is rupees 5,44,897 for Manin Boro bracket WPC 1923 of 2017. When is the next 1 lakh?
We need some more time.
When?
As the department needs 6 months time, lordship, for the payment. Up to you, lordship.
You give by next month. List the matter on after a month. Date. List the matter says by which date it is expected that some more money is provided to the petition.
I would like.
7.
My lord, I'll take your lordships to the order dated 16/9/2024. Lord, I want little time to get the further instruction. What is the position now?
Basically for settlement of some claim, insurance claim. Now, there is no adversarial approach from the other side. They are settling out, but then the report has to come. That's know how much has been settled and what is left. That is what is now pending.
Most of the claims are settled, my lord. Few are left, possibly, my lord.
If that report.
In the
will
meantime,
change,
substantial, my lord, compliance of the settlement is completed.
Okay. Right. Mr. S. Datta, learned senior counsel for the respondents number 2 to 4, submits that he needs further time to settle the claims of the petitioner.
Petitioner company,
Petition,
it's a company.
petitioner company. List the matter on
after 2 weeks.
Lordship, I record my petition.
Mr. A. Sharma appears for the petition. List the matter on, give a date.
Obliged.
I remain.
Is it infructuous? What is this matter?
Perhaps
Mutton and chicken shop, so what? 2018 matter.
And otherwise also lordship in page number 27, the petitioner
Huh?
claims, page number 27 of the writ petition, the petitioner claims to have furnished, preferred a representation before the municipal board, the town committee, which has now been become Rangapara Municipal Board. And in that representation also, there is no date or no acknowledgement whatsoever from any of the officials lordship.
What to do? The problem is this writ petition has come up
Lordship,
after 5 years,
lordship, after 5 years.
after 5.5 years.
Lordship. Now I am appearing for the municipal board, respect number 7. Here also, I am also at the moment not having any instruction as to the development of the issue. And even if that representation has been rightly referred, and today there is no counsel for the petition also. And there is no date for that representation also. No date, no acknowledgement of any official.
Right, no one appears for the petition on call. Mr.
P.N. Sharma,
P. Sharma appears for the
respect number 7, lordship.
point number 7. In the interest of justice, list the matter again on after 4th, 5th, 6th, 7th, 8th, 7th. One, let us see one chance, because I think it's all become infructuous.
Okay, in discussion, my lord, we are directed to file an affidavit, my lord. Till now, we could not file it, my lord. Yesterday only I got the instruction, my lord, and I pray for 2 weeks for the time to file an affidavit, my lord. Yeah, with the admissible amount that has already been paid, my lord.
No, you see, the thing is, what you have received instructions or not?
I received the instruction, my lord.
Which is to the effect that
The admissible amount that has already been paid here to the petitioner, my lord.
you see, I'll just read the order of 23 February.
My lord.
Mr. N.C. Das, learned senior counsel assisted by Ms. M. Bora, learned standing counsel Power Grid, has submitted a letter dated 22/2/24 to indicate that payment in question amounting to rupees 10,50,880 was already paid to the petitioner. However, Mr. S.D. Purkasta, learned counsel for the petitioner, submits that he has no instructions in this regard. So, petitioner's counsel was to obtain instructions.
No, Lordship, we have not received it. They have to supposed to file, PDP.
I'll continue reading the order. It says, list this matter in the next week on a date to be fixed by the registry to enable the counsel for the petitioner to obtain instructions as to whether the claim in the writ has already been paid to the petitioner or not.
Next order, my friend.
Yes, they heard Mr. S.D. Purkasta, so and so, please for little accommodation. Submitted communication. You see, does not appear to be a correct statement, and is not related to me. So, the entire thing has, just kept lingering like this. You all are not interested. You are also not interested. You are also not interested.
So, we have not received, Lordship.
You have not received.
But they are clear.
Lordship,
Within, my lord, the amount which has been paid to them, that is in respect of some other contract, my lord. That is not the correct position. For that, actually, we require to file an affidavit, my lord.
No, this 10 lakhs,
My lord.
50,880
My lord.
is with regard to the present issue or not?
The present, my lord, present contract, he is a subcontractor, my lord. The main contractor, the main contractor also not made a party in this petition, my
I
lord.
think,
we have made party. All our notice was served, Lordship.
No, you see, this is a disputed question of fact, you go to civil court.
No,
No, there is no disputed question. First, may kindly come to page 32.
32.
Page 32 of the writ petition. This is an admitted position.
Yeah.
They have paid 2 RA bills. And this is the last one. Page 32, first, paragraph number. 2 onwards, maybe.
As per this letter, 5,86,000.
Yes.
Now let us see your prayer.
They
Yeah,
are
yeah.
paid for entire 13 lakhs.
Yeah, that may amount, my lord, that have already, we have paid, my lord.
7
This is like, this is the instruction, my lord, we have received, my lord. 5,86,000,
You show me that.
my lord. It will be charged under the law. Only, my lord, the date is not yet mentioned, my lord, for that actually I am here. Because making a request to my client to give that on which that this is the amount was.
Third payment, this 5,86,000 has been paid.
Yeah, no, that has already been paid, my lord.
This contract is package A2. The case related to package A2.
Maybe, whatever.
There,
The same exact amount.
there are other works also, Lordship. Total amount in this package was rupees 31 lakh 69.
You go evidence, you take evidence. We do not know. The
It's
A
there.
to A3.
Page 32 is their record, Lordship.
Maybe.
It is been
Maybe.
sanctioned. It has been sanctioned. They have
This
to pay.
document has to be proved.
Ma'am.
This document has to be proved.
They have not denied it, Lordship.
The document has to be proved.
They have not denied it.
But why not filing affidavit?
They have filed affidavit, Lordship.
No,
Now,
no.
regarding
Originally, we have already filed our affidavit, my lord. Only about making this payment, my lord, so for that, actually, we require to file an additional affidavit, my lord.
You file this.
My lord, that way,
You filed within how much you dispose it of this?
my lord. Let it be after 2 weeks, my lord.
Mr. N.C. Das, Learned Senior Counsel for the
Just number.
power grid. For the power grid.
2, 3, and 2, 3, and 4, my lord.
For
And 5.
2, 3, 4 and 5.
Five.
He is granted 2 weeks time to file affidavit with regard to the letter dated 13/10/2024. Issued by. No, letter dated 13/10/2024 regarding payment made to the petitioner. This is the matter, give a date.
Let it be after 2 weeks, my lord.
You please file it.
No, that one.
Yes. Therefore, you're the daughter-in-law, what? No, you're the daughter-in-law.
Dear Lord.
I'm 6 and 7, newly implemented. 6 and 7.
Who is 6 and 7?
Because Goenka and they've been implemented in my
Who are you? What is your role?
lordship. I have been entered into an agreement for sale with the petitioner.
Oh,
So they have not been made as party, your lordship, then we have been implemented by filing an IA.
but then
Yes.
no permission, that permission to sale has been cancelled.
Yes.
But now the petitioner has sold the land to some other purchasers by returning our money back. Now we don't have any say on the lordship in this case.
She has sold it to somebody else.
Yes, your lordship.
How can she sell? No sale
Lordship,
permission.
already it has been cancelled.
Huh?
NOC has been cancelled.
Correct.
Lordship.
Anyway, we'll record this statement. Right, no one appears for the petitioner. Mr.
AK sir, my lordship.
A.K. Sharma appears for the respondent number 6 and 7.
Yes, sir.
So he submits that the respondents number 6 and 7 had been impleaded by the petitioner.
No, your lordship.
By-
By filing IA civil by myself.
By yourself.
Yes.
Had impleaded themselves by way of IAC number 423/2022. In view of the fact that an agreement to sell of the petitioner's land had been made with them. First of, however, the respondents number 6 and 7 have now come to learn that the petitioner has sold the land in question to some other person.
Yes.
Full stop. Next para.
We have
Sir,
received our money back, your lordship.
and the respondent number 6 and 7 have received the money back from the petitioner. Next para. Mr. S. Hussain, appearing for the respondent number 5, bracket daughter-in-law, submits that when the NOC for sale has been cancelled by the SDO,
By the additional Chief Judicial Magistrate.
by the,
Chief Judicial Magistrate, additional.
no, how can the-
ABC, your lordship.
cancelled by whom?
Sorry.
Cancelled by ADC, your lordship.
Cancelled by the
ADC.
ADC.
Respondent number-
ADC which district?
Barpeta.
Barpeta, comma. The petitioner could not have sold of the land. Full stop. However, as the petitioner is not present today, the matter is adjourned for a week. List the matter on your data. Eight.
Apply.
Huh?
Though the period is already over, your lordship, we are supposed to take whether the department is willing to waive off the interest, your lordship.
Correct.
But the department won't waive the interest, your lordship.
Not really.
Will not waive it because. Why will file? Because it's in the rule, your lordship.
Not required. If they don't want to wait, they cannot, they do not wait. It is their discretion. Whether it's correct or not, that's a different issue. They don't have to file any affidavit.
And the MMC rules.
They don't have to file, Mr. Counsel. Are you out of hearing? Heard, Mr. F.U. Barber, learned counsel for the petition. And Mr.
R.R. Gogoi, your lordship.
R.R. Goyal, learned counsel for the forest department.
All the respondent.
For all the response. Mr. R.R. Goyal, learned counsel for the respondent submits that the forest department is not willing to waive the interest on the kissed money in view of,
Rule 38, your lordship.
in view of Rule 38. Of
30,
the
sub rule 6,
Rule 38 bracket 6 of the,
if I may, your lordship. Whereby the charge has been given with the relate interest, he has to pay, your lordship.
in terms of the Rule so 6, Roman 6, okay, 37 bracket 3 bracket Roman 6 small, huh? Of the Assam minor mineral concession rules, comma 2013. So I'll give you a chance if you want to, you can have a hearing on this.
Because they are not entitled, because first time they asked me, I am paying for FMDR against on interest against the FMDR amount. But they are not entitled because they have recently asked. The interest they are not entitled. I am ready to deposit the MMDR, but interest they are not entitled.
He entered into an agreement with the department, lordship, which
So that is why
That
you
is
see, Mr. Counsel, you want to have the, you want to make a submission now, I'll dispose it off. I'll give you another day if you want, that's all. On the prayer of the petitions council, list the matter on. List the matter after 2 weeks. On which date an attempt shall be made to dispose of the matter. You think clearly.
No blind. No.
92-22.
Please, your lordship. Lordship, in regards to item number 19 and 22, the petitioner no longer wants for a
19 and
22, lordship.
22. Okay, Mr.
Yes, sir.
A. Saranya, learned counsel for the petitioner. Petitioner in WPC 5863 of 22 and 5319 of 22. Submits that upon instructions, the petitioner does not wish to press the above two cases. So, sir. You are there, Ms. Yuda. Next, in view of the submission made by Mr. A. Sarania, counsel for the petitioner, the above two writ petitions, that is 5863 of 22 and 5319 of 22, are dismissed as not pressed. Then what about the other one? S.M. Raman. This, anyway, these seem to be infructuous, I think, this writ petition.
In regard, also combined that with item number 1922, lordship, it has become infructuous.
That's why he also said infructuous actually. That's why he's not coming. It's of 22. July 22, 2 years have passed. NIT has been cancelled 2 years back. There is no stay order also. I think. No stay order, no? Right, right. This item 20 and 21. No one appears for the petitioner. Is this infructuous?
My lord.
Is this infructuous?
Yes, my lord, it is almost the update instruction not available. I have, but
You have not read the file at all. You only rely on instructions. Please read the file at times.
actually,
The petitioner is 11th.
11, my lord, already
11th. His number 11. His bid is number 11. Okay, right. No one appears for the petition also. Huh? The math, huh? Oh, wait, okay. This one, this is 19. 19 and 22 can go. No one appears for the petition also. Mr.
RK Mushari.
R.K. Mushari
Yes, sir.
appears for the BTC. The matter pertains to the cancellation of the NIT dated 12/11/2021 for settlement of Mahal's white impugned order dated 20/07/2022. You're not here, Mr. Counsel. Your case is finished. Yes, you're there in 2021.
Yeah, no, I mean, I cannot 1920.
That we have already disposed. Very good. One last chance we'll give them. For what? In the interest of justice, list the matter in the next week. Both. Huh. I just said the before saying in the interest of justice, you just say the matter appears to be infracted.
23 and 24.
Lordship, yes, he said, into.
Yeah.
Money,
Yeah.
আপনাকে কিছু ব্যাপার করতে
Where is Mr. Ikaram?
এই ব্লগের
Oh.
প্রিন্টটা তের ভাই আছে তো মোবাইলে
Okay, then tell them.
সব কপি দিয়ে দিও মানে I have received the instruction madam
This is item 23.
23 and 24.
Yes.
So many DAX numbers are there, madam. Lots of place to pay with and I'm not sure the
Can I have?
Huh?
Can I get a copy of?
No, I'll.
Why don't you file
WhatsApp
affidavit?
copy.
Let them file an affidavit
Mine.
incorporating this.
Mine,
So this
sir.
will better. It will record a content.
Mine.
Let it be on record. Let it be filed. So we'll get a copy.
You file this affidavit.
My lord.
Ms. Udas, Senior Government Advocate, submits that. As she has received instructions by way of letter dated 22/10/24, issued by the Additional District Commissioner, Fishery, Barpita. She would like to file the same in the form of an affidavit. How much time?
2 weeks, madam.
2 weeks time is granted. This is a matter after 2 weeks.
All right.
Give a date. Then what remains?
My lord, yes, most of the, my lord, water bodies, my lord, under periodic patta. But my lord, the petitioner states that his pattas number 384, those are not in that, my lord, list. But some of the portion of other DAG of the petitioner are in the water.
But the ones that he has mentioned are not there.
His mentioned are not there, but other parts of these land are also
So
there.
what is to be done then?
That is also lordship, I asked the deputy commissioner, additional deputy commissioner, he is also, my lord, up to the court, my lord. Because
No, now I think we have got to wait for a few more months. Water level will go down, your land will be restored to you.
actually, my lord, 7 years settlement was there, but it was handed over later on. Otherwise, 7 years would have been, my lord, over, because in the year 2017, that's fishery was settled with the, my lord, Gopal Sarkar, but it was handed over only in the year 2021, my lord.
Also in the petition, only patta number has been mentioned, that number has not been mentioned.
Patta number will be a second. My lord,
Let them file.
instruction will be, my lord. Obliged, instruction. will be.
Item 25.
No, make it after that. Item 25. Yes. Yes, have you brought the evaluation report?
Yes, sir, I have filed additional affidavit.
When?
Uh, on August, madam.
August.
Yes, madam. Sunil Sohoria.
It is not here. It is not in the record. I don't have any additional affidavit. It is not in the records.
Madam, that may be called, madam.
What is the filing number? Do you know?
Madam, filing the base.
Whether the respondent number 6 has fulfilled all the claims, all the requirements.
Yes, sir.
We have been already awarded the what?
That much I know. That's why no stay was given.
Yes, ma'am.
Only thing is that the additional affidavit has clarified that issue over. Huh?
Contract period is only for 1 year, madam. Then almost 1 period over.
But what is the filing number?
Madam, I'm giving the filing number.
Okay. Right. Ms. A. Gayan submits. Ms. A. Gayan submits that the evaluation report dated 22/9/2023 has been filed by way of an additional affidavit in this court
On August,
in August 2024. And the filing number is dash.
I'm giving.
Registry to place the same in the record. List the matter when? When will he be well? Huh?
Short date.
Short date. Day after tomorrow. When? Next week. Huh? Next Tuesday.
Time being item 46.
Yes.
Look, my learned friend.
Lordship will find it from annexure 4, that is letter dated 9/4/2012, Lordship.
Annexure 4. Annexure 4.
That is, it will be page number
yes, yes.
1, 2, 3,
Yes.
5, the 5th page, Lordship. 5th page, Lordship. By this letter, Lordship, the concerned PCME has been entrusted to lay the guidelines and all. Liberty has been given, liberty has been given to him, Lordship. Then Lordship will find, Lordship,
So correct. That is there.
Yes.
That is there in the letter of 2019 also.
19 also.
Then-
So he has been given all the rights. Then Lordship, that's 2019 Lordship. That has been approved by the Railway Board. That will Lordship find the letter dated 8/4/2019. On the basis of recommendation of a 5-member committee, Lordship. Lordship find letter dated 8/4/2019 of the
Yes,
Railway
yes.
Board. The next page, Lordship, 7/2/17, the Railway Board has approved. And the recommendation, consent recommendation, Lordship find it serial number 5F, roof mounted package unit. Why it should be from the approved RMPU, that is means the Lordship, the originate who manufactured that.
No, what are you trying to say? What are you trying to say?
That we want to engage this origin, the OMB Lordship only. Why that justification has been given, Lordship?
But what about, okay, What about the other railways, western, northern
They may
railways?
take the decision at their own, and because that only not binding, that is only
So,
suggestive. That is
so,
only a suggestion.
now the issue is this. If, you see, the thing is that, so they can take a decision contrary to the decision taken by the NF railway also, the western railways or the northern railways. Correct?
Lordship, in fact, the justification has been given, Lordship. E-filing note, Lordship. E-filing note, Lordship. That has been, his representation has been disposed of. And this is the justification given last page. Lordship. That copy, of course, is not communicated to, is filing note, Lordship. They'll be issued within a day or two, Lordship. This ACCIE, Lordship, this now is a semi-skilled person, Lordship. Earlier, that one person is to look after both the bed linen and the AC. Now it has been changed, Lordship.
No, it's okay, but then it is not a case that they cannot do it.
No, he doesn't have the RDSO. Lordship, he doesn't have the.
But even the
RDSO.
southern railways did not have, they were not there. The southern railways also doesn't require that.
They might have relaxed this condition, but because we are not bound by that condition,
bound.
Lordship. We can win. In fact, we are following this in the Rajdhani and Shatabdi, Lordship. And Lordship, whether with terms and condition, Lordship will interfere in sitting over, not sitting over a appeal. I will be relying on that, Lordship, on judgment, Lordship.
There is one aspect of the matter.
Absconse case, Lordship.
If no, that is there. What about if there's going to be a lower cost?
No, that has been justified. Why we do not want it?
Where?
In the reason given, Lordship. And Lordship will file in the recommendation also, Lordship. That letter of the railway board dated 7/2/17. And in the letter dated 7/2/17, Lordship. 7/2/17. The recommendation made under clause 5F.
In this letter, they have justified the cost factor.
Cost may be more, but we can put the responsibility.
The
to
consequent recovery of penalties.
If anything goes wrong, Lordship.
Along with the added value arising from the better quality of service, will more than adequately cover for the extra cost.
And my lord, he is running the 3-4 trains in the south, Lordship. It's not that he is out of work, Lordship. Own admission in the writ petition, Lordship. He's doing work for 3-4 trains in the south, Lordship. And he's basically from the Kerala, Lordship.
But if he's due from the south, that means he must be a manufacturer.
No, he doesn't claim. He doesn't claim.
Because south does not require that condition of manufacturer.
They have relaxed them now.
Yes.
As far as our work is concerned, we are undertaking only one work presently at the Southern Gateway. There is not 2-3 works I am taking. It's wrong. Secondly, under NF Railway, I don't know any other. Only one aspect I would like to impress upon. The earlier tender cost was 15 and off. Now it is 21.
21?
Crore. Present under the present enactment. That is the only aspect because that's why Railway Board FSI Then why are you insisting on a manufacturer? Because he's not a contract for supply. It's
Oh.
a service contract.
No, I understand that part. Only problem is out here they're trying to justify that cost factor.
That you
That is the
also will
problem.
examine. That is the only aspect.
That is the only aspect. That is the only
My,
aspect.
my only ambition is, it's not that Lordship will award the contract, only Lordship will allow us to permit, to participate. And rest Lordship will examine the matter, whether this is in public interest. At least Article 14 part Lordship can already take note of. Only will participate subject to fire orders to be passed by the law. I leave it to your Lordship, my lord. My only prayer is, can railway.
But supposing at the end of the day, supposing we allow the writ petition,
Yes.
then the issue is there'll be other persons like you also.
No, question is because.
There'll be other persons like you also who should be considered.
In that case, Lordship will say the advertisement condition should be changed. Supposing if a Lordship finds favor in our contention, the Lordship can always move the relief by saying, now a fresh advertisement should.
When is the
Last
contract
two
for,
days,
no, but the who is
Three years.
NF Railway, who is operating the NF Railway right now? You all are not operating.
We are not operating. My lord, it so happens, my lord.
Yeah.
Supposing there is some court case or something, they always extend for 2-3 months. That is not big difficult. It happens. In the exigencies of the business of the railways, my lord, they can always do that. I was only thinking, my lord, Lordship will, I'm leaving it to your Lordship, my lord. Let us participate, Lordship will examine the matter. It has got an element of opportunity.
No, I was thinking of that also with regard to the cost factor. But the cost factor is now sought to be explained by them. That's the problem.
6 crore public money. My lord, the earlier contract was given on 14/12/2020. Now this December it will come to an end.
What?
The earlier contract, presently under the NF Railway, this was issued on 14/12/2020. Last month it was over. So already they are on extension.
And that is being run by somebody else.
No, some other party that is on extension until we not.
You all are not running it.
No. Only that is the aspect, my lord, the railway board decision and the public interest part. I leave it to your lordship.
Yes, what is happening to Western Railway and Northern Railway? How are they running their train?
We only relied on the Southern Railway part.
Mr. Council, yesterday I specifically told you, please obtain instructions with regard to Western, Northern, Eastern.
That aspect.
Because we have got to see all the other aspects also. Not only one side of the
It's
country.
not binding on us, Lord. That is our step.
Whether it's binding or not is correct according to you, that is the thing. But for this court to take a decision, we want the inputs from all the other railways also, division.
Uniformity in the decision.
Yes, sir. So that otherwise, you see, what is happening is that something is legal down there, something is illegal down.
And if that has been done only in 2019 and 20, Lord. Thereafter, there is no such.
No, but then in 22 yesterday they showed in 22, November 22. You are still following that after 19 and 2021.
We are in 24 now.
Correct. Now, so what made you change? What was the difference between then and now?
Technology changes each and every day, Lord.
Technology changes.
So
changes. What about Western India?
skilled person has to be deployed, Lord.
What about the Western zone? What about the Northern zone, Eastern zone?
Whether they're after 22, some documents has not come up before this court today, Lord.
And okay, I don't know. Yeah. How fast can you file an affidavit?
It's 10 days time.
So they cannot finalize the tender by 10 days.
So you don't act upon we will stay the tender process for the
Oh,
time.
Lordship, let us accept the tender, let us accept the tender, but we should not fix anything.
Or Lordship, that they will not finalize my tender, let me submit for the president. Lordship can decide.
No. You see, only one problem is later on, if it goes in your favor, just in case it goes in your favor, then everything should be thrown open to everybody, not only to you. That is in the back of my
For a
mind.
period of two weeks, we will nothing.
Because otherwise only you will be
Yes. I can follow.
eligible and having a better rate than others.
Yes.
Naturally.
Similar person similarly placed like.
Correct,
us
correct.
can also participate.
Yes, only because of that.
In that case, for 2 weeks, why not also we keep it in whole status for the day
Will not finalize.
Yes.
But lordship, that should not put in my admission clause.
No, no, no. Heard Mr. K. Chaudhary.
In any case, they are lordship, but it's, they are viewing the proceeding also. In any case, they must be viewing the proceeding also.
Could be, could be. Even if they're viewing the proceeding, the issue.
Yesterday, lots of it already dictated a part of.
That's what I think I'll just copy paste. You see, the only thing that really is of importance right here is with regard to the cost factor. Because there is some public element involved there.
But
As-
they have justified lordship.
That is justified, we'll have to go see that. But if you can add some more with regard to what is the stand taken by the Western Railways, Northern Railways, Eastern Railways.
Whether that will be binding on us also.
No, whether binding or yes, all those things, but whether it's binding or not, what is their stand? And how does it, why is NF Railway taking a completely different stand?
We're following all the circular that I have placed before lordship.
Huh?
I have almost placed all the circulars.
Because you see, the rail network in India, I think this is a very small sector.
Yes, smallest of the entire.
Compared to northern, western, southern, eastern. So let us see. So that we have at least even if we pass some judgment, might be wrong, might be right, but at least it will sound and look as if it's a reasoned order.
But we runs the longest train from Agartala to Trivandrum lordship.
Okay, Trivandrum to
Agartala
Agartala.
to Trivandrum.
The longest.
Long.
Okay. How long does it take?
What 4 days?
We used to go by this Brahmaputra mail.
In our days, Mela, it used to be Tinsukia Mail and Brahmaputra Mail. These are the
Bra-
two things.
Brahmaputra mail used to take us
To Delhi. Mela.
3 nights, 2 days. You have to go with the entire, big tiffin so that you eat on the way, drink on the way.
Take part in the state. That all.
Bath or no chance.
Those days.
Yeah, water. Okay, right. Heard Mr. K. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. G. Goswami, learned counsel. Also heard Mr. B. Chakrabarti, learned CGC. Can you take this order, huh? Till here, okay. Then Mr. B. Chakrabarti has submitted various letters which is to the effect that the decision whether to relax the condition to outsource the job of ACCEA for escorting AC coaches has been left to the discretion of the principal chief mechanical engineers of the various divisions of the Indian Railways all over the country. He submits that the NF Railway have taken a decision to outsource the job of ACCEA for escorting AC coaches only to the tenderers who are manufacturers and suppliers of electrical items who are in the list of approved vendors issued by the RDSO. Full stop. He further submits that by keeping all the maintenance with the OEM, what is the OEM?
Equipment manufacturer.
With the original equipment manufacturer bracket OEM, comma, there will be an expectation of some extra cost. But on the whole, the added value arising from better quality of service / performance of AC would more than adequately cover the extra cost. Full stop. Next paragraph. On considering the submissions made by the council for the parties, comma, this court is of the view that the savings that might arise from following the earlier system is a factor to be considered as the same pertains to public interest. Full stop. Further, this court is also of the view that the policy that is sought to be followed by the Western, Northern and Eastern railways should also be brought to the notice of this court. In as much as the policy sought to be followed by the NF railways is not the policy being followed by the Southern railways.
Nothing, my submission may be recorded, that's not binding that. We can follow our independent.
Acha, before that, you're right, Mr. B. Chakravarti. I've already said that discretion of the various division. I've already said that. Next para. This court is of the view that, in view of the above reasons, a careful consideration of the issue would have to be undertaken. Though this court is aware of the judgment of the apex court in AFCONS.
2016 SSC, page 801.
Wherein the Supreme Court has held that the author of the tender is the best person to understand its needs and interpret the tender conditions. List Mr. B. Chakrabarti shall accordingly submit an affidavit within 10 days.
10 days.
Within 10 days. Within 10 days. Within 10 days. Which should include the queries raised in this order. List the matter on, give it 11. 11, 11. Full stop. The NF railway, in the meantime, shall be allowed to continue with the tender process in terms of the tender number ELGH 965 dated 1/10/2024. Till the stage of opening of the technical bid. Okay. Till the stage of opening of the technical bid. This is the matter of.
Item 26.
So here, my lord, so far as the relief claim by the petitioner,
Item 20.
item 26. Lordship, kindly see page 33 for a moment. The work is, my lord.
You have to file
Construction-
an affidavit.
Yeah, otherwise, my lord, I've seen it, my lord, there is nothing, my lord, survives up, because after the termination of the contract, petitioner himself participated in the, my lord, tender process. He was disqualified and it has been issued to the third party. Without any protest, he participated. Now he is challenging the termination order, challenging the entire tender process after he was disqualified. Lordship will see the prayer. You
Okay, let
just
us
straight
see.
back,
Let us see the prayer.
page 33, Lordship will see the first work order issued to the petitioner.
No, because the prayer in the nature of
Yes, my lord, Lordship will see
to
the
set
prayer.
aside and quite the notice dated 2010-2023. Where is this 2010-2023?
Yes, sir.
Where is this? Where is this 2010?
2010, 23 is not an expression. 2010, not an expression.
Where is this 2010-2023? You are in the prayer, your first prayer.
Next item, my lord.
Is infractuous, then we close it.
Yeah, yes.
Next item.
Okay, right. Heard Mr. Triple S Raman, learned counsel for the petitioner who submits that the writ petition is infructuous. Mr. B. Ogoy appears for the PWD. So in view of the submission made by Mr. Triple S Raman, the writ petition is closed as infructuous.
Next item.
27.
Now, what have you prayed here?
My lord. First, my lord.
You have completed 85%. How much? Or 50%? How much?
Two, my lord. Three, my lord.
So no, not so. You don't answer a question with so. The question is whether you have completed 50% or 85%. 85%. So yeah. Huh?
Five point 14% work I have completed, my lord. Next page, my lord. Next page. Bill number 24 in the first page, then on the next page, what you find, second side, 85.14%, my lord.
But how do we know this is your contract?
It's the online, my lord. I downloaded it from the online.
Deka Chang to Gao Ka Tadia.
My lord.
Here my instruction is awaited.
Yeah, report, man.
Huh?
Here my instruction is awaited.
Here your instruction is awaited.
Yeah. I've got the, my lord, I have communicated to them, my lord, it's awaited. I can have it, my lord.
So 85% of the, then what happened? What about the 15%?
They have to apply because
Terminated.
my lord, at came, my lord, the result, my lord, I could not complete their work. So, my lord, they have terminated my contract and my lord, third party, my lord. In the first.
Given to a third party.
At item number 20.
But your prayer here, let us see your prayer. payment of 12 lakhs 24,065.
1 crore. 1 crore 20 lakhs.
Prayer number 1.
No, that is
That penalty, deduction
the
of that
penalty
penalty.
part.
There is the penalty.
Okay. Let him obtain instructions with regards to this.
If my lord, on the next day my instruction.
Huh?
If on the next day instruction doesn't come, my lord. Taken up, my lord. Or-
Yeah, my lord,
2024.
one submission, my lord. He has challenged the penalty part, but termination order is not under challenge in this split
On
petition.
5
right?
days, my lord, they have taken time for filing it and everything. 5 days, my lord. And he on 12/8, then 27.
Lordship will post it on my after 2 weeks.
Mr. Counsel, when was the contract terminated?
It's coming, my lord. On my lord. 29, 7/20.
29/7/20. Yes,
I will file
Mr.
affidavit, my lord.
Mr. B. Gogoi, Land Counsel for the PWD, submits that he will file affidavit.
I will have the instruction and file affidavit.
Submits that he will file, obtain instruction and file affidavit within
My lord, Lordship will post it after 2
within
weeks.
3 weeks. List
3
the
weeks.
matter on.
Oblige, sir.
28.
No affidavit.
The ground on which they have refused to clear the amount.
In the meantime, my lord, a subsequent development has taken place, my lord. To work out the committee has been constituted, my lord. This initially the amount is very high, my lord. Thereafter, we took other vehicle on hire in a very lower price, my lord. There is a scam going on in that they take in the higher price, then this dumping and all these things. My lord. Therefore, a committee has been constituted to have work out everything and then pass the
Your work.
So that is all right.
my lord, because these are all public money, my lord.
That cannot be, your lordship. They have issued work order, your lordship. I have supplied, your lordship.
Lord,
Look, no. You see, whatever, you make one committee, you make 20 committees, it's all right. That is not a problem. Only thing is that we want a reply to his queries, that's all.
Because they are new development. This is of 1510, my lord. Because
So when can you, so this cannot be a ground for giving you
Lordship will allow
lot of
weeks
time.
time. In the meantime, the committee may give a report and maybe his entire amount may be bill may be passed.
So how much time does this committee need?
Well, I will get the instruction because it has been given to me.
You see, it's a very simple thing.
Let it be posted after 2 weeks. Well, in the meantime, I will get the entire. Even the committee might give a final report.
No, you ask the committee,
That's it.
within how much time will they give a decision?
Lordship will post it after 2 weeks. Well, in the meantime, the committee will examine and even find that this amount can be released. My lord. Since they have given the work order.
Fact, your lordship, in another order, your lordship, passed by this honorable court, your lordship, that this honorable court is pleased to reject the ground owned by them, your lordship.
Huh?
That the grounds owned by them for refusing to pay me, your lordship.
No, that's not the issue. Out here, there is no affidavit filed, there is no admission. And your the use of your vehicle was when? The dumpster was when? Which year?
Lordship, 2022.
Lordship will find that in page number 16.
Look, this committee, whether you form this committee or a bigger committee or 20 committees, doesn't matter. You take a decision, that's all. Cannot be a ground.
Lordship will post it after 2 weeks. Well, in the meantime, I will get the instruction and everything.
June 24th, file on 24th June. Wait some time. Right. Mr. S. Bora, Leonard Counsel, for the respondents number 1 to 4 submits that the Commissioner GMC has constituted a committee White order dated 15/10/24, comprising the following officers. Comprising of the following officers, comma, to review the engagement of hired dumpsters bills submitted by the petitioner. Comma, which are as follows, huh? One, two, I'll give the name. The additional commissioner, GMC, chairman, okay, number one. Number two is the chief engineer, GMC dash member. Number three is branch officer, Janzala branch, JNXALA, branch GMC member. Chief accounts and audit officer, GMC member. Number five, the executive engineer, Janzala branch GMC member. Number six, assistant executive engineer, Janzala branch member. Number seven, law officer, GMC member. Next paragraph. The order further states that the committee will review and examine the bills, and after thorough consideration will submit the final report to the Commissioner GMC. Next paragraph. It is hoped that the committee constituted by an order dated 15/10/2024 will take a decision at the earliest with regard to the claim made by the petitioner. Accordingly, list this matter on after 3 weeks.
No. 29. My lord, we have received instruction, we would like to file an affidavit.
Okay, Mr. M. Chettiar, Learned State Council submits that instructions have been received and he will be filing affidavit within
3 weeks, madam.
3 weeks. Give the matter up.
Item same.
Huh?
Item 30.
30 also same order.
Same.
May I get it?
Give it.
31.
My lord, in this case, we have filed one IA for getting the interim order vacated. This IA is not on list, my lord. May I pray the matter may be taken up on Friday along with the IA?
Friday, okay. Right.
Yes, sir. Monday.
Wednesday?
Yeah.
No, not Wednesday.
Tuesday.
29.
Okay, Mr.
S. Chakrabarti.
S. Chakrabarti, Learned Counsel
For
for
the respondent ONGC.
the ONGC submits that an application for vacating the stay order has been filed
On Monday, 21/10.
on 21/10/2024. White filing number
Yes, my lord, I'll give the filing.
white filing number dash, huh? Registry to list the same along with this petition on Tuesday.
32.
Interim order will have to continue.
Interim order to continue till the next week.
My lord, this matter, Lordship, we like to, my lord, dispose of because the read petition was filed. Saying on the ground, my lord, that he filed an appeal before the appellate authority was not sitting. Therefore, interim protection was given till the appellate authority sits. In the meantime, the appellate authority has admitted his appeal and granted him the interim relief. So, Lordship.
Since already the appellate authority is there, I have taken up the matter and I have already granted the protection. I think this can be.
Okay.
A lot of the order.
Right. Right, Mr. Y.S. Manan, Learned Counsel for the petitioner. And Mr. P.K. Roy, Learned Senior Counsel for the respondent number
2 to 7.
2 to 7. Let's take this last order dated 11/9/2024,
Yes,
huh?
sir.
Para 2 and 3. The counsels for the parties submit that subsequent to the filing of the writ petition, an appeal has been filed.
The appeal was filed.
Earlier.
And submit that subsequent to the filing of the writ petition, the appeal filed earlier, before the Central Government Industrial Tribunal come Labor Court, Guwahati. But this number is different.
My lord, in fact, it is an employees provident fund appellate authority. my lord.
No, no.
He wa- he
the
wa- he was-
appeal was, okay,
No, he was given the power, my lord, to as an, he was designated as an appellate authority under the act.
okay, very well said. The counsel for the parties submit that subsequent to the filing of the writ petition, the appeal filed by the petitioner before the appellate authority, vide EPF bracket A bracket close number 03/2022 has been taken up, and the appeal proceedings are pending before the appellate authority. Further, protection has been given to the writ petition by the appellate authority as on date. The counsels for the parties thus submit that the present writ petition has become infructuous.
Lord.
Next para. In view of the submissions made by the counsel for the party, the writ petition is closed as infructuous.
33.
No one appears for the other side. What is this? B. Gogoi. Datta. What to do? Oh, yeah.
Your lordship, the settlement period is already over.
Settlement period is over.
Apologies, lord. It's the next item.
So what it happens? It reminds me of me going to a wedding. I went to the wrong church. Then after the function was over, having tea, I don't know all these any of the persons. I looked at the bride and the groom, no idea who they were. Happens then. Anyway. Yeah, for a fun amount. What have you got to say?
It is under the domain of the PWD department, my lord.
PWD is not here. Okay, right. Mr. S. Hawk appears for the petitioner. Mr.
Take it up.
A.K. Datta appears for the respondents number
1.
1 and 2. 1 and 2. No one appears for the PWD respondents number 3 and 4. This is the matter. Accordingly, in the interest of justice, this is the matter after a week.
34 for orders.
In this matter, they are supposed to file their affidavit. My lord, interim order is continued, my lord, and all these years they have shown no interest.
Mr. Counsel, this you have been settled with the with this what is mining activity?
My lord, it's a matter of stone quarry.
Stone quarry.
I was the first bidder.
Correct.
And,
Now,
and the stone quarry was allotted to me
for how many years?
for 5 years.
5 years.
For 5 years.
Then
And
when was it allotted to you?
my lord, in 2017, man.
17.
17.
And when did 5 years end?
No, my lord, that is there, my lord. Only one thing I would like to point to, my lord. Till date, due to operation of the stay order,
What's the order?
my lord, kindly come to the stay order, interim order.
Yes. Stay order, yes. So now, so because of the stay order, what has happened?
My lord,
Fresh NIT is not, so you have been running the stone quarry from since then?
no, my lord. I was, they said that the quantity of the query that was not advertised and the tender was less. That was the person of chief conservator of forest.
So you never,
And they cancel my bid. Against that, I have approached your lord. Your lordship said that no fresh tender and ask them to take instructions. And till that manner, they have not.
so Mr. Council, one thing.
My lord.
This is a issue regarding a 2017.
Thereafter,
NIT.
COVID came, my lord. in
COVID
2020.
came. That now you can't expect to run a stone quarry at 2017 rates in 2014.
My lord, kindly consider, that is there. Kindly consider one thing, my lord. They did not allow me to operate a query. That way, they lose their revenue.
They lose. What to do?
My lord,
No,
the
now
state
if
has-
they allow you,
my lord,
they're going to lose more
my-
because the rates 7 years earlier and 7 years hence is different.
And
What was the price of petrol 7 years earlier?
very true.
Then
Only thing is, my lord, all these years, my earnest money and all, those are blocked. My
they will give you back.
They did not allow me to operate the query. Neither they
They
operated.
did naturally because they you are disqualified.
They approach your lordship.
Earnest money was returned back, Lord.
And it's money returned back.
It is in the petition itself.
Okay.
The petitioner was informed.
But remain.
I have not received.
In whose petition? In the petition, writ petition?
Yes, Lord.
There is no point keeping this pending. This is just
My lord,
no,
some sort of consideration.
no. What consideration? We cannot allow you to run a
Yeah.
stone quarry
That is there.
after so many years.
Or maybe I may be allowed to continue with trace market value.
I think thing will have to be done. A fresh tender notice will have to be issued. Because due to a flux of time, nothing else, not on the merits of the.
That is there.
Because you see, 2017 listed ones, 2019 listed ones, then after that 2024.
Man.
Fault of the petitioner for not pursuing his matter, fault of the court also for not having it listed within time. So because of that, state government should not suffer.
And
Your
they-
fault, fault of the court also, because of that, state government should not suffer.
And they did not approach your lordship with say vacating activity, whatever.
True.
Their fault also.
Everyone's fault. So what to do?
But at the end of the day, I am the loser.
Yes, in a way. But then you also, why did you keep quiet?
My lord.
2017, you got a stay order. You kept quiet. 2018, you did nothing. 2019, it was listed in
That is-
September.
That is there.
Huh? For 2 years, you kept quiet. Then after that, for another 4 years, you kept quiet. 5 years. Yes, anything to say?
From my perusal of the records, Lordship, the settlement was never awarded. The petitioner was only informed that the petitioner was the highest bidder. Thereafter, the PCCF intervened and said that this project will not be viable,
Not
which is
viable.
why the entire process was cancelled. And at page 25, Lordship, the petition, the petitioner was informed about this and he was asked to take back his earnest money.
In 2017, did he take back?
He has no instruction.
Huh?
That instruction I don't.
Anyway, whether he is going to take it back, you take back. That's all. There's no point fighting over these cases because nothing will happen.
Only thing is,
Right. But where do you say it's 5 years? It's 7 years over. You said 5 years.
Right.
Seven years. It's from 7 years. Right.
that
Heard,
means,
Mr. Huh?
that means up to 20.
24 gone. Now 24 is gone. This NIT is of March 2017. So even if it was settled, basically no use now. So now it's October, going to be November 2020. Right. Heard Mr. G. Vaishya, Learned Counsel for the petitioner, as well as Mr. I. Bhattakur, Learned Counsel for the
Forest Department.
Forest Department. The matter pertains to the grant of mining contract of the Chapra Kata Hill Stone Quarry under the AIE Valley Division, Bongaigaon, for which an NIT was issued on 18/3/2017 by the DFO AIE Valley Division, Bongaigaon. The stipulated quantity of stone was specified at 17,500 cubic meters. And the settlement period was to be for a period of 7 years. The petitioner was one out of 7 tenderers who quoted their bids. Next paragraph. As can be seen from the comparative chart made by the DFO, the petitioner's bid was the highest at rupees 3,65, 55,555. The DFO thereafter made a recommendation for settlement of the stone quarry with the petitioner on 3/5/2017 to the Conservator of Forests, Lower Assam Social Forestry Circle, Bongaigaon. While the petitioner was expecting settlement of the stone quarry, the Office of the Principal Chief Conservator of Forests and Head of the Forest Force, Assam, issued the impugned letter dated
applicant.
Huh? The impugned letter dated 19/8/2007. Stating that, asking the DFO to submit justification for fixing the stipulated quantity of stones to be extracted as 17,500 cubic meters for 7 years, without delineating the boundary and the area. As the grant assigned per year appeared to be very low. Don't say impugned, don't say impugned. No, you cut the impugned. Full stop. Next para. The DFO, in his clarificatory letter dated 27/10/2017, thereafter stated that the calculation of the stone materials at 17,500 cubic meters was on the basis that the maximum Mahal materials are earmarked for supply for government work. Full stop. Disregarding the above report on the quantification made by the DFO, the DFO, the principal chief conservator of forest bracket P issued the impugned letter dated 30/10/2017. Stating that the tender process initiated by the DFO AIE Valley Division NIT dated 18/3/2017 was cancelled as the annual stipulated quantity of stones was very low. Good stuff. The principal chief conservator of forests was thereafter. The principal chief conservator of forests, Lower Assam Division was thereafter requested to instruct the DFO to carry out proper assessment of the quantity of stone available in the Chapra Kata Hill Stone Quarry and put the mining contract area for fresh sale by inviting a fresh NIT, after refixing the quantity of stone as well as the government value and reserve price for the said mining contract area. Full stop. The petitioner, next para, the petitioner being agreed, has thereafter filed the present case. Challenging the decision of the respondent in cancelling the NIT and the fresh NIT that was proposed to be issued. This court, vide order dated 8/12/2017, thereafter passed an interim order directing that a fresh NIT for the said stone quarry should not be issued pursuant to the impugned letter dated 30/10/2017 issued by the PCCF, SL. This court has heard the submissions made by the council for the party. However, this court is of the view that the present case would only be of academic interest, in as much as the issue with regard to settlement of the stone quarry for mining purposes is only meant to earn revenue for the state. The NIT for settlement of the mining area was for a period of 7 years, and that period has expired as on date, keeping in view that the NIT was issued on 18/3/2007, and the recommendation for settlement of the mining area had been done on 3/5/2017. Which was not acceptable to the higher authorities. Next para. The petitioner was never settled with the mining contract. And in fact, the petitioner had also been asked to take back his earnest money as far back as November 2007. Wide letter dated 10/11/2017, issued by the DFO. Next para. This court is of the view that, in view of the fact that more than 7 years have passed since the issuance of the NIT, dated 18/3/2017, it would be in the interest of the public exchequer if a fresh NIT is issued for settlement of the stone quarry, keeping in view the rate of inflation and the fact that the prices, the fact that the price of stones is much higher now than it was in the year 2017. Accordingly, in view of the reasons, the present the writ petition cannot be allowed. Only on account of efflux of time and on account of efflux of time. This writ petition is not being decided on the basis of merit, due to the reasons stated. Accordingly, the writ petition is dismissed, with liberty being given to the state respondents to issue a fresh NIT for fresh NIT for settlement of the stone quarry, said stone quarry. Full stop. The earnest money of the petitioner, if not returned, shall be returned back immediately. Disbursement. Okay, just a this. When? Trustee affidavit filed on can you see the order dated 17/7/23, So what about 73? Service of notice upon this point number 1 is complete. That's all. But then this order has the subsequent order.
18-9, my lord.
Huh?
Since, my lord, the matter relating to the, my lord, money of, my lord, compensation. So, my lord, the honorable court, my lord, feel that the, my lord, the private respondent is required to appear before the. So again, very system, my lord.
I know, but then, but no report is there. So what to do?
Sometime maybe,
Huh?
sometime maybe, even
Right. Petitioner's counsel is present. In terms of the order dated 18-9-2024, the petitioner has taken special steps for service of notice upon the respondent number 1. However, the office note dated 21-10-24 states that there is no service report regarding completion of service. Await service report. This is the matter after 2 weeks.
postal Talavana maybe.
Huh?
Postal Talavana.
Or we send it to the Lawazima court. Huh? Just list the matter before the Lawazima court. We'll take a decision with regard to the service report on the respondent number. This is the matter after 3 weeks.
30 seconds.
Lord, we do have instruction, but Lordship, there is no clarity whether the amount is admitted or not. That is why, Lordship, the matter may be disposed of in terms of Tamshe with the direction to the chief engineer.
Okay, right. Third, Mr. D. Khalita, learned counsel for the petition. Ms. Sai Bhattakur appears for the
PHA department.
PHA department. While Mr. M. Chetria appears for respondent number 3. Then you take this para 2 of order dated 16/3/2020. To stop next. Mr. I. Bhattakur, learned counsel for the PHA department, submits that though instructions have been received with regard to the present writ petition, the instructions received are vague, and despite clarifications being sought for, clarifications have not been given till date by the state respondents. I have heard the counsel for the parties. It is seen that despite the writ petition having been filed on 9/3/2022, the state respondents have not been able to give any specific answers to the claim made by the petitioner, even after a lapse of more than 2.5 years. Consequently, this court is of the view that the respondents would have to verify the claim of the petitioner in terms of the judgment of the full bench of this court in Tamsher Ali versus Union of India, reported in 2008, whatever. Next. Who will do the verification?
Chief engineer.
The respondent number 2 is accordingly directed to verify the claim of the petitioner and take a decision on the same within a period of then payment also is required.
3 months.
Within a period of 2 months from the date of receipt of a certified copy of this Pustak. Thereafter, if the thereafter, no, if the respondent number 2 comes to a finding that the petitioner is to be paid some amount, some outstanding amount, comma, the same should be the said payment should be made to him within a further period of 2 months. Also. All the respondents are directed to ensure that the funds for payment of outstanding admitted liability, comma, if any, is made available in the event the respondent number 2 comes to a finding that the petitioner is entitled to some outstanding amount. The writ petition is accordingly disposed.
Same thing.
Same. Now, what is the amount out here?
2,52,000.
Huh? 2,52,000. And this writ petition was filed on 9 March 22, same day.
Item 38.
Of like.
Mining contract was given to respondent of CVT and the selling. So is this order? And no affidavit also, I have to take instruction on what is the petition.
As per my instruction, work is already completed.
Ah, must be. What is the work?
It's 70 madam. Immediate measures for restoration of first floor artisan fund.
Ah, for the year 2021-22.
No, it is NIT, madam. NIT, 2022, December, madam.
Huh?
NIT is December 2022, madam. Then work was given in 2020.
Yes,
February.
on 15th February 23.
You
Two monsoons have gone by, Mr. Council. All
They
finished.
check the TV. The order is not there, madam. Normally,
Correct. You call him up, but there's nothing now. He's saying that the work has been completed. What remains?
what you record that, madam.
Yeah. Okay, right. Heard Mr. B. Chakrabarti, Learned Counsel for the petition, and Ms. R. Deka for the
Water issue.
Water Resource Department. So stop. Also heard Ms.
Be for it.
B. Soren for this point number 3. The petitioner's case is that the petitioner participated in the tender process floated by the Water Resource Department while NIT dated 2012-22 for the work, inverted commas, immediate measures for restoration of Balbala marginal bund at different reaches in between paragraph 3 of the writ petition. The petitioner's technical bid was disqualified and the respondent number 3 was allotted the contract work on 15 to 2023. The petitioner has challenged the disqualification of his technical bid and has also challenged the credentials of the respondent number 3. To be allotted the contractor. Next person. Miss R. Dekha, the learned counsel for the. No, Mr. P. Chakrabarti, learned counsel for the petition submits that he has not been given any up-to-date instructions by his client as on date. On the other hand, Ms. R. Dekha, appearing for the Water Resource Department, submits that the work contract allotted to the respondent number 3 has been completed by the respondent number, as there was no stay order passed by this court. In view of the submission made by Ms. R. Dekha, counsel for the Water Resource Department, it appears that the writ petition has become infructuous. According to the writ petition is dismissed as
Obliged.
41. AC, yeah. No one appears for the petition on call. The matter pertains to non-payment of contractual dues. No affidavit has been filed by the state respondents as well. In the interest of justice, list the matter after 3 weeks. Make it 4 weeks. 42.
Presently, video is running the market.
Huh?
Video is running the market. Hello, doctor.
So what does it mean? You have not taken a decision.
Yet not lordship. Lordship may direct for participation lordship then.
This Ratan Boro is the respondent number 6. So now you are operating the market. That is by assistant video. That means by the respondent number 5 basically. Correct? Have you got this letter?
Yes, I've seen.
Yes, sir. So, and the correction of toll will be operated by Shri Dhiren Talukdar assistant video and so on until further on. So we'll dispose of this case with the direction that they should pay. Correct. Third, Mr. Ardha, learned counsel for the petition, and Ms. R.B. Bora, learned counsel for the BTC.
BTC.
Yes, sir. The petitioner's case is that, then you carry on, that the petitioner had participated, para 1, order dated 20/09/24. Then you write, the petitioner's counsel submits. Next para, that as the petitioner's bid was the highest, the petitioner, the weekly market, the bi-weekly market has to be settled with the petitioner. Next para. Ms. R.B. Bora has submitted letter dated 23/9/2024 issued by, no say letter, say office order dated. Office order dated 23/9/2024 issued by the respondent number
Five. Five.
5, which is to the effect that the respondent number 6 has been directed not to collect the toll fee of the said market, and the responsibility of collection of the toll fee would be operated by the assistant BDO and Shri Dimbeshwar Barman, Gram Sevak, until further order. Ms. R.B. Bora submits that no final decision has been taken by the respondents, state respondent, in pursuant to the NIT dated 6/6/2020. Correct. In pursuant to the selection process conducted under the NIT dated 3. Okay. I have heard the learned counsel for the point. Keeping in view the fact that the bids of the bidders pursuant to the NIT dated 6/6/2024 has been open. It is incumbent on the part of the state respondents to select the successful bidder to operate the above market. Accordingly, the respondents are who do we direct accordingly the video or what? Is he a party?
Respondent number 2, CSD. 2 and 3. 2 and 3.
According to the response number 2 and 3 directed to conclude the selection process pursuant to the NIT dated 6/6/2024 and settle the at Thia Bari bi-weekly market with the successful tenderer within a period of
1 month.
within a period of 3 weeks from the date of receipt of a certified copy of the order. The writ petition is accordingly disposed of. Before that, the office order dated 23/9/2024 is made a part of the record and marked as Annexure X. The writ petition is accordingly disposed.
Deeply.
Item number 41, I just in the permit. We have already taken this step. Item 41, non-payment of protection. The agency is 41.
Not do. What was there? What was the order? For what?
Petitioners. They have already admitted the activity is directed to the matter.
Huh?
They have already admitted the.
Where is their affidavit?
Affidavit shall be the copy.
No one appears as it.
I not with them.
You cannot just come barge in whenever you want next. I said after 2 weeks. You make it 2 weeks.
Supplementary admission item 50.
Yeah, please. Difficult on the part of the council, my lord, of the review petition. You always difficult. The lordship has passed there's been an order on 28/2024. What happened, my lord? The council represented this company made a wrong submission before the company. That is the unfortunate that is created some problem. Please the matter, different putting heat is not powered by the
There's two aspects, my lord. One is in the tea estate, there is a tea plantation, and one is tea dressing planting. Now, replanting is, which is we covered, that is uprooted the tea bushes and planting on the same plot of land. And replacement is to replace the bushes in some other plots. So there is major distinct difference between the two. And we are covered by the scheme under clause 11. When the Planning Council is submitted on the behalf of the petitioner, that is covered by clause 3, which is the completion period is 6 months from the NOC. In our case, in fact, it is 36 months from the date of replacement, which is we are covered. So that is the difficulty we are faced, and therefore we are again.
Why don't you go to the, go in appeal? Because
Lordship
this
has,
is, this is.
Lordship has not, this is not on the, in fact, it's the misconception placed by the Learned Council. It is wrong on our part. It's not wrong on the part of the court. The court has correctly said that yes, it is 36 months, 6 months. You are beyond that. So, it petition deposed. But that is the whole difficulty. My humble request is to Lordship, please examine the matter on merit. And
No, what are you saying? We are out here, they are asking for subsidy. And there are two schemes. One is the 11 scheme and one is the 12 scheme.
Now, what
So-
happened, my lord?
So just a minute.
Yeah.
So you had applied for subsidy as per the 11 scheme.
Now, what happened, my lord? I'm just explaining for a minute. We start there are two sections. One
No,
section we have
let-
completed in a 11 scheme.
Correct.
Now the second replantation, that is commenced when the second scheme came in force.
But when did you get the approval to start the scheme, work on the scheme? When did you get the approval?
Yes.
When?
No, there is no question of approval, my lord. What is that before completion of the
No,
replantation-
you have to apply for grant of the scheme, correct?
Yes.
Of the subsidy.
No, we have applied for.
You have
Now-
applied on 23/11/2012.
Their objection is only, as per their counter objection, their objection is that I have applied in a single application. Now their contention is you have to apply two applications. That is their contention. But in the earlier scheme, when we commenced it, that there is no amendment. There is a provision of single application. Now in the subsequent scheme, there is a provision of two applications. So that is not covered in our covered matter. That is whole difficulties, my lord. So our case is covered by clause C11. So we completed within a 36 months. Absolutely. So therefore we are entitled. So Lordship may kindly.
I'm not. I'm still not getting it. Unless I am, you see, and if you're taking so much time in trying to make me understand whether.
So Lordship, if your Lordship kindly give me a minute, I will just. I will just some dates are there which covered my case. Absolutely covered. Otherwise, we will not before this honorable court. I rest assure my lord that I will not advise my client to come before this honorable court again. Lordship will be satisfied and will genuinely satisfied, my lord, that we have a married here.
No, you tell me, okay, what is your case? Tell me from the beginning.
Yes. Lordship will kindly have a look, the lead application near file. Along with the review application, the entire lead application.
Read application?
Read petition. Read petition along with all the annexed documents.
Give me the read petition.
It's a review application.
Yeah,
itself.
okay.
Lordship will find at page 27.
27.
Lordship kindly have a look at page 4.
Just a minute, just a minute. 1 thing.
Seven.
7, yes.
Yes. Para 4.
27 is the start of a repetition.
Yes. Page 31 is paragraph.
Page 31. Yes, para 4.
Here. May I read it?
Yes.
That the petitioner which fulfilled the laid down eligibility criteria under the scheme submitted an application.
No, Mr. Not this way. You've got to tell me in very simple language,
Yes,
not
yes.
reading and.
Clearly.
You see, a review petition has to be very simple.
May I invite the attention of the honorable court to the scheme, my lord?
You see, the basic thing that I know out there is that you applied for subsidy under the scheme.
Yeah.
Here you had applied for the approval to work under the 11 scheme into the year 2012. Approval was given to you
Yeah.
in the year 2012.
Yeah.
And then you started it.
Yes.
Now you started it, you completed one part of the scheme.
No, lordship. We have completed it in 2015. So what our contention is,
It is.
within the time.
Huh?
The lordship kindly have it go at the scheme.
No, but you are asking for subsidy under which scheme?
No. Our contention is that for the second uprooting plan and the replantation, we are eligible for the enhanced amount under the 12. That is our contention.
Correct.
And that we are eligible because we had commenced and we completed during the course of the 12th year. That's it. Kindly have a peruse the page 47. That's it.
Yes.
Lordship, kindly have a look. C3. 47. C3.
Yes.
C3 uprooting will have to be completed by 31st March. That is that. Replacement planting to be completed within 6 months from the date of announcement.
Yeah.
Now, that is not our case, we submitted with the council representative. And in the judgment in para 12, Lordship has correctly says on the basis of the statement placed by the Ranat Council. Lordship, have a kindly look 11, page 48. Page 48. Which is covered out. Page 4. Replanting in all cases shall be completed within 36 months from the date of completion of uprooting. This uprooting against replacement planting will also have to be completed within 36 months from the date of completion of the replacement planting. Our case is completely covered within the 36 months. That is the difficulty. So we are entitled for the enhanced subsidy. Their only contention is that we have made a single application. That cannot be. It is as per the scheme we have applied. That is their only contention.
Replanting in all cases.
Yes, that is the difference.
No, but then you see, but then your application for subsidy was made during the 11th scheme.
Yes. 11th scheme, we made a first application and it's continuing. In 12 itself, we have made a.
Where does it say that if you have started the replanting in the 11th scheme, then if there's a new scheme that comes in between, you will be entitled to the benefits of the subsequent.
But this 11th scheme that overlapped by the 12th scheme, and we are completed in 2015.
No, but where does it say that the schemes that were started or the work started under the 11th scheme, if completed during the application of the subsequent scheme, will be governed by the.
I follow the query of the economic.
Then
now the 36 months will start from the replacement. Now these 36 months completed in 2015. So either have to be. If they say I'm entitled for the 11 also, and for this enhancement, I am for one section, I am entitled for 12. That is my case.
I don't find anything.
Because I have completed in 2015 within the time limit.
Maybe.
As per C11.
But you have to show the connection between the 12th scheme and the. Is there anything in the 12th scheme which says that things which were started in the 11th scheme and which ended during the coming into force of the 12th scheme would be governed by the 12th scheme? Where is that?
I understand the query, my lord. But the 11 and 12, there is no difference in the scheme.
Maybe.
The difference is they enhance the subsidy amount.
Correct. So that is the basic difference.
Yes.
What do you, that's the main difference, in fact.
So I am.
The money is the main thing. So
Therefore, we made a representation before that, that since we are, that in 2014, the 11th scheme expired and is replaced by the 12th scheme. Now in 2015, we have completed. So we are saying.
You can make a claim under the 11th scheme if you want, if you think you are eligible, but I do not know, you'll have to, unless you are able to show this court, what this court wants.
Why they have rejected my application, my lord? That's what we have annexed there. Why they have rejected my application?
I think you should try your luck before the DB.
Lord, can we have a look at this? I hope, my lord, if we have, if all the documents.
No, there cannot be an appeal in this, guys.
No, I'm not, nothing. I'm only saying, your lordship, that the finding based on my wrong submission. That is the whole trouble with that.
No, whether that submission was there or not. Now even as per your own submission, you had applied for being covered by the 11th scheme during the application of the 11th scheme, and approval had been given. Now you started the scheme during the 11th scheme, but you completed it only when the 12th scheme came into force.
Within the time limit. The time limit has not been changed. Time limit has not been changed.
Maybe.
Oh,
Maybe time limit has not been changed. But time limit is there. But then where does it say that if you start your work under the 11th scheme and you complete the work within the period given in the 11th scheme, that you would be given the subsidy in terms of a new scheme that replaces the old scheme? Where does
May I suggest one thing, if you will not seek the approval? That
you can, in that case, you can say that since the 11th scheme had provided you 36 months, then, and as you have completed the work as per the time schedule given in the 11th scheme, even if the 11th scheme has been replaced by a subsequent scheme, you are still entitled to subsidy as per the 11th scheme, then I understand. Not the 12th scheme. Where does 12th scheme come into the picture? I don't understand. No, it's not the fact end, Mr. Council. It is only not even 3 o'clock.
Now, what I suggest, what I propose, or subject to lordship, that lordship may accept it, and we'll place the entire thing before the.
No,
we'll say-
nothing like that. You have got to satisfy me in the first instance. Then only I'll issue notice. You don't satisfy me in the first instance, then I'm giving you a lot of time, Mr. Council.
Yes.
It's this is a review. This is a review matter. This is not a. This is not.
I boiled down this on court. I'm grateful.
No. You have got to show me that you are entitled to the 12th scheme. You're not entitled. This 36 months that has been given under the 11th scheme pertains to the benefits to be given under the 11th scheme. There is no way in the 11th scheme or in the 12th scheme stating that if you complete within the time limit provided under the 11th scheme, and though a new scheme may have replaced the 11th scheme, then you'd be entitled to the payment made by the subsequent scheme or by the old scheme. You've got to show me that. There is nothing to show.
My contention is, my lord, that their objection to my representation to get the benefit of the 12th, their only contention is that you have to apply 2 applications. That is their only objection by the people. Nothing more.
There has to be a finality to issues, Mr. Council. These, if you have not pressed on some issues, in a writ petition, we all know, lawyers put 20 points and then they press only 1 or 2 points. So if you carry on, then tomorrow, supposing I dismiss your case now, then some other lawyer will come and they'll say that, my lord, he did not press upon this point. This point was an issue. And then it will carry on. You'll have review after review, it will never end.
At the outset, I say, my lord, that is very difficult on the part of the counsel of the petitioner to persuade the court. It is very difficult on the part of our. I understand, my lord. I understand. But still, it's my duty to pursue the honorable court.
You can try. And if you have a case, if I feel that you have a case, I've got no problem in issuing notice. Only problem is I'm not convinced. You convince me that that there has been some error apparent on the face of the record.
No, because
No, even supposing what you say is correct, that even if I discard the stand taken by the earlier council, as per the stand taken by you today, I do not find any reason to to come to a finding that you're entitled to subsidy as per the trust scheme.
may take some time, my lord. Because the point raised by this honorable court is also very pertinent. And that may be examined by. Lordship.
This is a review, Mr. Council. You're not supposed to go in depth into a matter. It's everything has to be straight away. It should be seen. There's no requirement of having a long thought out reasoning to be done.
That end, I go it down.
Right. Heard Mr. Bhaskar Datta, learned counsel for the then senior counsel for the review petition, who submits that the order dated 29/8/2024, passed in WPC number 6359/2016, should be recalled, inasmuch as there is no error in the judgment passed by this court. However, the decision made by this court in the impugned order dated 29/8/2024 has been due to a wrong submission made by the counsel for the review petitioner at the time of disposal of the writ petition. He submits that the stand of the review petitioner's counsel at the time of disposal of the writ petition was with regard to the applicability of clause 6.3.
See within bracket 3.
6 bracket 3. C bracket 3 of the which scheme?
11th. The scheme name
Of the 12th scheme.
Tea Development and Promotion Scheme for Implementation.
That is the tea development
and
promotion scheme, inverted commas, huh? Tea development. He submits that the applicable clause is in fact C bracket 11. The review petitioner's counsel submits that there is no infirmity with the reasoning of this court in the order dated 29/8/2024, wherein this court has rightly held that the review petitioner was not entitled to any subsidy in terms of the 12th scheme when the work to be done had been completed during the applicability of the 11th scheme. Full stop. However, the actual fact is that the work in question for availing the subsidy under the 11th scheme started during the application of the 11th scheme. The 11th scheme
can be covered by the 11.
The 11th scheme was thereafter replaced by the 12th scheme with effect from
2015.
with effect from when? From 10/12/2014. Full stop. As the petitioner had started his work under the 11th scheme, and as clause C bracket 11 of the 12th scheme provided that the replanting in all cases should be completed within 36 months from the completion of uprooting, comma, the petitioner was entitled to the grant of subsidy under the 12th scheme. Full stop. Now, full stop, in the comma, as the replanting had been completed
10/12/2015.
on 10/12/2015, comma, those started during the application of the 11th scheme. Now, what does the 11th scheme say? When is the period for completion?
Completion is
36 months, same as
that is not
same.
Ah,
Full stop. Next paragraph. This court is finding it difficult to understand the this court is finding it difficult to understand as to how the petitioner would be entitled to the subsidy provided under the 12th scheme when the petitioner had applied for grant of subsidy as per the 11th scheme, while letter dated 23/11/2012 in respect of section 25 bracket P and section 16 of the Tea Garden. Further, the Tea Board of India, while letter dated 12/12/2012 had given no objection certificate to the petitioners for commencing and uprooting the tree bushes in respect of section 16 and section 25P. Full stop. Just because the petitioner, as the petitioner had started his work for availing the subsidy under the 11th scheme during the validity of the 11th scheme, the petitioner would have to show that he was entitled to be given the benefit of the 12th scheme, as the replanting had been completed by the petitioner during the not during the had completed the replanting when after the 11th scheme had been replaced by the 12th. Either I dismiss or I give you one more chance that's all.
one more chance.
When? Because I don't find anything. Frankly, I don't know why I should. Let's say I think you should go DB. I think. No, I think so. Unless they are able to show.
Yes, I understand.
You understand my
Yes.
query.
But it is spoken.
Next. As no, in view of the above reasons, no. Next, in the case of so, the Supreme Court has held us so, Then, next para. In view of the reasons stated above, this court does not find that any grounds for review of the impugned order has been made out. The review petition is accordingly dismissed.
Get to
51.
Can you take a few other?
both connected matter. Same.
51, 52.
Right. Already.
Yes, what about this? Where is the Dusty, where is the affidavit of Dusty service?
That is the difficulty. We submitted on 4th of October for that statement. However, until it wasn't ready. On 15th we made a tentative, but the person concerned was on leave. Usually we have taken it on we have got a copy yesterday. So we may be allowed to take this step today or maybe tomorrow. Only till last year. Otherwise, the postal service has completed. As in we have taken steps. And with regard to the affidavit of the JFJ has not filed.
Lordship, we've received the instructions and are already working on the affidavit. Lordship, a further 2 weeks time may be granted. We'll file our affidavit.
But it also allow us.
Huh?
Will also allow us to take the step to justice.
If you do not file an affidavit within a week, we are going to vacate the interim order.
My apologies that we have reached it out.
No affidavit of service. No, Mr.
Deedek.
Deedek appears for the petition. No affidavit of service of notice upon the respondent's number 3, upon respondent number 3 has been filed by the petitioner despite the order dated 3/10/2020. Yes, sir. As a last chance, the petitioner is granted a week's time to submit affidavit of service on respondent number 3. Failing which, the interim order is liable to be vacated. Yes, sir. Miss
A. Bhattakur, appearing on behalf of P. Nayak.
A. Bhattakur appearing on behalf of Mr. P. Nayak, then counsel for the respondent number 1 and 2.
Lordship JMC.
1 and 2.
1 and 2.
Submits that affidavit will be filed within
2 weeks time, Lordship.
2 weeks. This is the matter after 2 weeks.
Okay.
Huh?
Contract, may give it date also.
You did.
It prior age 80 20. Thank you.
Obliged. Lordship, senior health was not good.
Huh?
Was there, but he went back.
Huh?
Senior,
What happened?
he went back because of
He went back where?
unwellness in the morning.
Went back home. To do what? To sleep?
Huh?
Afternoon siesta. To do what? Madam, we have got a case here. You were the one also here, the same today or yesterday you
I think 25.
Today. 25.
25.
Why does he go back knowing that there are cases here?
My lord, particular lordship can be a small matter. Can the lordship takes up this matter tomorrow? It's a hearing day. My lord, the whole case is an award was passed by the Labour Court by proceeding expert. Now we have questioned that award. Firstly, if we can satisfy that the Labour Court was wrong in proceeding expertise, then that is one thing. And even if we fail, then also from the materials on record, we can ideally substantiate my argument that there was absolutely no materials before the Labour Court to pass this. So it's absolute false. It won't take much time. The person who has been directed to be reinstated with back wages, there is no evidence with regard to his employment, with regard to his getting salary, something else, which is a payment receipt.
There is a stay order passed by this court.
Yes.
There. No hurry.
My lord.
No, the problem, no, it's not that. The problem is we have fixed cases every day. That's the thing. I think from today, tomorrow we have fixed cases. From tomorrow, all the fixed cases are going to come up.
If something happens, otherwise, problem is, my lord, it will come up on that day. Maybe I'll have some difficulty and it will be difficult to take an adjournment. I think that is a very old pending matter, 2016 matter.
What do you think we are doing?
No, my lord, that is not, my lord, I'll take out, we'll take out.
You are-
Possible, my lord.
You see, here we are also burdened. We also have to do some reading.
It be there tomorrow, if possible, if time permits, and if
No.
something
Tomorrow case is already fixed. Not
on 29th.
after. Fifth already we have fixed. Huh? Fifth. Right. Petitioners council is present. However, adjournment prayer has been made on behalf of Mr.
Yes, sir.
S. Sahu, council for the point number 2. On the ground that he has already left for his house, for his residence,
Because of
without any
because of unwellness.
unwellness.
Yes.
That's a new word to me. Unwellness.
I said.
Huh?
I said.
Actually, you should say he's not feeling well. Unwellness, so I don't think that's a proper word. Yeah.
He's not feeling well.
Yeah.
that's why.
Yeah.
He's not feeling well. That's what I meant.
As he is not feeling well. Accordingly, this is matter on 12.